constantly, or do they have to, is voice activated? How do the microphones work? What about the front desk here? Speak. I can't hear you.
They can hear us definitely over the WebEx.
You're on WebEx, right?
What?
I'll try it. Say something again.
Hello?
I can barely hear you.
You're gonna have to talk louder.
Or maybe it's WebEx that's messing it up.
So I think he has it slightly turned down.
No, he just turned it up. For you.
Shalana, can you
Can
speak?
you hear me?
This, Anna,
Hello?
you're good.
Hello?
I don't hear Shalana.
I think if she takes her mask.
Hello?
There.
Yes,
Y'all are all soft talkers, so just talk.
And
louder
just-
like Marcia.
just about 6 feet.
Hey.
That's great. Cheerleader voice is.
So we know you want to scream sometime.
Yeah, you are not going to need to raise your voice today, Anna.
All right, before we get started, let me remind visitors that are with us today that if you're here for continuing education, it could be a pretty easy 8 hours of continuing education as long as you signed in and sign out and stay here during the entire term of the meeting, which might be several hours. It won't be 2 days. It might only be half a day. I don't know. Well, we never know what it's going to look like, but make sure you've signed in. That's how with Aaron Smith, who's back at that back table, keeps track of who gets credit and who doesn't. So with that said, in only moments from now, we'll get this meeting started, but I want to take one more opportunity to thank the Central West Tennessee Association of Realtors for hosting us, commission and staff, at a dinner last night. It was an exceptionally good time, at least from my perspective, and I think everybody else would agree with that. So we appreciate that, guys. It's always a pleasure to come down to Jackson. It's one of the easiest places we go to as far as hospitality and convenience, and we look forward to it. I'm not going to say I look forward to it more than Memphis because we have a couple of Memphis people on here, but from my perspective, I like stopping at Jackson. All right. With that said, we'll call the meeting, May meeting of the Tennessee Real Estate Commission to order, and we'll ask the Executive Director of the Tennessee Real Estate Commission, Caitlin Maxwell, to read a public disclaimer into the record. Caitlin.
Yes. Notice the May 7th, 2021 meeting of the Real Estate Commission, including date, time, and location, has been noticed on the Tennessee Real Estate website since August 26, 2020. Additionally, this month's agenda has been posted on the website since Friday, April 30th, 2021.
Thank you.
For the roll, Commissioner Joe Begley,
Here.
Commissioner Jeff Diaz,
Here.
Commissioner DJ Ferris,
Here.
Commissioner Marcia Franks,
Here.
Commissioner Steve Gwen,
Here.
Commissioner John Moffett,
Here.
Commissioner Joan Smith,
Here.
Commissioner Stacy Torbett,
Here.
Chairman John Cruz.
Here. So we have a full complement, 8 in person, 1 virtually. And at this point, I'm going to ask Commissioner Stacy Torbett from Johnson City to give the invocation. And following that, I'll ask Commissioner Joan Smith from right here in Humboldt, almost right here in Humboldt, to lead us in the pledge. Commissioner Torbett.
Bow our heads. Dear Heavenly Father, thank you so much for this day. Thank you for the opportunity to be here. Thank you for the safe travel for those of us who have driven. I just ask that you be with us today. Help us to honor you with our words and actions. To this name, amen.
Amen. Please stand.
Amen.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God,
Individual,
liberty,
with liberty and justice for all.
As some of you may be aware, because we talked to you about it last night, this is the first time this commission has met in person in, 15 months or so. And it's the first time a couple of commissioners have actually appeared in person over that period of time because they've been appointed since we last met in person. So Commissioner Smith, right beside me here, this your first meeting in person, and DJ Ferris at the end from Nashville, his first meeting in person. I think everybody else has spent some time together, but we enjoyed being together and with you folks last night. We'll do that during the day today. And if you have questions during the break, feel free to approach us or staff. Don't fight us or do anything that causes pain, but we're happy to talk to you. We're glad to see people we can talk to. All right, with that said, we have to approve today's agenda. Commissioners, you may note that you received an updated agenda in the paperwork in front of you this morning. You'll know it's the updated agenda if you see candidate A at 8:45 on the agenda. So that's the agenda we're working off of. So the question I have is there a motion to approve this agenda, or is there a desire to modify it in some way or another?
Move to approve.
Second.
I have a motion by Ms. Frank, second by Mr. Diaz, that the agenda be adopted as presented. All right, next we have to approve last month's minutes.
Got to do a roll call.
We have to roll call that one. I cannot just say, everybody seems to think it's okay. Call the roll. Because we have a member virtually, and there's a good reason he's virtual today, we have to, every vote will have to be a roll call vote. So stand by. If you're in favor of the motion to approve the agenda as presented, you'll vote yes. If you're opposed, you'll vote no.
Commissioner Begley,
Yes. Yeah.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Yes.
Commissioner Franks,
Yes.
Commissioner Gwynn,
Yes.
Commissioner Moffett,
Yes.
Commissioner Smith,
Yes.
Commissioner Torbett,
Yes.
Chairman Grease.
Yes, so the agenda is adopted. Now let's approve last month's minutes. Is there a motion to
Looking for
approve?
that?
So moved.
Second.
Thanks,
Sitting right here.
Got a motion by Steve Gwynn from Memphis, seconded by Jeff Diaz from Memphis. Set that agenda. Those minutes from last month be approved as presented. Discussion, any corrections or additions? None, let's vote. If you're in favor of the motion, when your name is called, you'll vote yes. If you're opposed, you vote no.
Commissioner Begley,
Yes.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Yes.
Commissioner Franks,
Yes.
Commissioner Gwynn,
Yes.
Commissioner Moffett,
Yes.
Commissioner Smith,
Yes.
Commissioner Torbett,
Yes.
Chairman Grease.
Yes, the motion passes and last month's minutes are approved. Now, at this point on your agenda, you'll see something referenced as an informal appearance and candidate A. And I have no idea who that candidate is. Apparently, the person or persons is going to appear virtually. Is that correct, Caitlin? Is
Yes.
that person on?
Angela Powell.
Yes, ma'am, I'm here.
Okay, great.
Let me see. Where's Angela?
Do you need me to turn my camera on?
If you would, it would help us.
Okay. I have it on. Can you see me?
Will you wave at us?
Let me see if I can. Okay.
Wave at us, Angela.
Can you hear me? Can you see me?
I can hear you, but I'm not sure I see you yet.
Okay, I've got a dual camera coming up. Do you see me now?
Can you wave at us?
I'm waving.
I think
When we don't see you.
Yeah. Well, let's proceed. Hopefully we can make a determination out without seeing you, but it's good to know who we're talking to.
Yes, sir.
Yeah.
I'm trying to give you trying to log on here.
In the meantime, Angela, I'm going to ask Ms. Maxwell to give us a little background on why you're here this morning.
Okay, before you, you have applicant Angela Powell and her principal broker Corey Hammonds.
Is there a principal broker here as well?
I see Corey Hammonds
Yeah, I'm
on
here.
the. Here, okay,
What's his name, Corey?
Corey Hammonds. Okay, at the time this was written, Ms. Powell had not yet taken the real estate Tennessee broker exam. The firm is Hammonds Group. A summary of the criminal and disciplinary sanction is felony theft burglary. Ms. Powell's statement and a letter of recommendation can be found on your iPad.
Okay, so would you tell me, I can't hear you well, Corey, what's his last?
Hammonds.
Corey Hammond.
Yeah, that, and that,
Shake
that
it up
information
and
should be,
because-
that information is on your iPad.
Okay. All right, Ms. Powell, Mr. Hammond, the way we typically handle these is we get a little bit of background, which is kind of like hardly any information from our executive director. We just received that. And then we ask the applicant and give her or him as much time as he or she would like to have to tell us what got you to this position. What is it that caused you to have to come before this board? When did it happen? What were the events? What circumstances? What have you been doing since then? Why do you want to get a real estate license? The floor is yours, and you can tell us anything you'd like to tell us that you think might help your case. Following that statement, commissioners will have the opportunity to ask you questions. And following that portion, we'll ask Mr. Hammond to explain to us why he would like to have you associated with his firm. Finally, commissioners can ask Mr. Hammond questions as well before we ultimately get to a vote to either approve your application to proceed to get a real estate license or deny it. So that's kind of how the process works. Ms. Powell, I'm going to give you the floor. Tell us what happened. Give us the details you think are important.
Yes, sir. So, so in 1992, I was 18 years old, and I had just graduated from Brentwood High School. My parents had went out of town and did not leave me any money. I had already left home at that point after I graduated. So I went to the house. Some friends took me. I did have a car, but they drove me. And I went in and, you know, got some money out of the safe, which I did let my parents know. The day after that, the friends that took me over there went back and burglarized the entire home. My parents did go back and forth with Williamson County and the district attorney, letting them know that, you know, it was not me that actually did the burglary and the theft. I mean, the house was completely destroyed. And the individuals turned states on me and said that I actually had planned that. And so I was prosecuted for that. And they let them go. Again, my parents fought for many years for them not to prosecute me, but that's what happened. My parents have written a letter, and I do have that letter. I did not submit it to the board at the time that I sent my paperwork because my mother had not wrote it. So I had two children in between that time. I had a son in 93, a daughter in 95. And I completed my sentence at TDOC with no problem. Coming up to 2016, I had owned my own Airbnb cleaning service for several years. There was an insurance fraud that had taken place, and I will take responsibility for that. I was sentenced in Davidson County for 4 years on probation. I did complete all of my probation with no violations. Of course, no dirty drug screens because I don't use drugs. Never had any problems with my probation. I came off my probation December 20th, 2020. And the entire time that I was on probation, I continued to run my own business, the Airbnb cleaning service. I do raise or partially raise my 5-year-old granddaughter. My daughter just graduated from Lane University there in Jackson on the 17th of April. So she was there for 4 years, just coming in on the weekend. So that's why I had my granddaughter. And like I said, I do take full responsibility for everything. I just want to move past it. And I want to be a productive citizen in this society. And I want also other people to know that just because you make a mistake does not mean that you can't, you know, further your education or do what you want to do in life. And as far as being a realtor, actually my dad is a part-time realtor, and he's been doing that for many years. He's also high chain of command at CenturyLink. So we try to follow in the steps of our parents the best. I know I did not do that, but I am trying to do that now. And I love to talk. I love to meet new people. I don't like to be in a cubicle. So I think this is a good profession for me. I feel like I can sell an igloo to someone in Florida. So that's why I want to be in this profession.
Okay, Angela, thank you. Commissioners, any questions? Ms. Franks?
Good morning, Angela. I'm a little bit confused. So we heard that the charges were felony theft and burglary. So I take that's what you were charged with when your friends robbed your parents' house. Is that correct?
Yes,
Yeah.
ma'am, because when my parents went to prosecute the other individuals, they had turned states on me, which means they put everything on me and said that they didn't do it. So the DA chose to prosecute me and let them go.
Okay, so what was your sentence for the felony theft and burglary?
It was initially 7 years, and then I had another 4 that was running concurrent, so it was a total of 11. But I only did 2 years in TDOC.
And what is TLC?
TDOC is the women's prison on Stewart's Ferry in Nashville, Tennessee.
Okay, all right. So the paperwork that we have, the criminal court records, we
Yes,
have
yeah.
3 of them, and there's 3 of them that say insurance fraud. So tell me about the insurance fraud. What happened there?
It was some money that was obtained, illegally. It was sent in that, an accident had happened and the insurance paid me. And now the other 2 counts, they just ran those concurrent. I think the other 2, I can't remember if they dropped those, but I only received a 1 sentence, which was 4 years on the $1,500 claim. But I did, in fact, I have paid the insurance company back. That was part of my probation to do a full restitution, and I did. And I also paid all of my court costs and all of my monthly payments to probation.
And did you pay those, or did your family pay those?
I paid some of those, but my family did. My mother and dad did pay the court costs because it was almost $7,000. And I did make the monthly payments for the restitution and the monthly payments for probation.
And
And I
so,
was also, I'm sorry,
Go
go ahead.
you
I
go
was
ahead.
also granted some leniency on the monthly payments because of having my granddaughter. I didn't per se work every day. I only cleaned, Airbnbs maybe 3 times a week or whenever someone would check out. So they did bump me down to only having to pay $15 a month for that.
So did you have to serve any jail time with that insurance fraud?
No, ma'am. When I was arrested, my parents made my bond that evening, and I never served any jail time. No, ma'am.
So is the insurance fraud a felony?
Yes, ma'am.
Okay, that's all I have. Thank you.
Other
Thank you.
commissioners?
Question. What
Let me-
question?
Let me go first to Anna.
Hold on
By
one
the
second.
way, folks in the audience, Anna Matlock is our legal counsel assigned to us by the Department of Commerce and Insurance. She tries to tell us what we should and shouldn't do sometimes. Sometimes we listen.
I just wanted to clarify, there is a mistake on the first page of your informal appearance package for this particular candidate. You should only be seeing the charge for insurance fraud. If you look in the other documents, that's the only one we're considering today because it's within the 10-year time frame. The candidate has shared with us past matters, but that's not to be considered today on the determination for whether she is to be able to get a license or not. So the only matters that you are going to consider is the insurance claim that is marked on your documents in 2016. Those are the only things that you should see. Everything else is redacted.
And just to be clear, what date should,
2016.
2016?
2016.
Okay. Commissioner Gwen?
I missed the total on, what was the total insurance fraud? What was the number?
The amount was
The amount,
$1,500.
yes, the amount.
$1,500. And again, I did pay that back in full to the company.
Thank you.
Other commissioners? All right, Mr. Hammond, you've got the floor. Please tell us why you're interested in having Ms. Powell associated with your company.
Well, I received a phone call and she reached out to me, and I was kind of shocked by, her request. And so what I did was, well, let me tell you a little bit about myself, I guess. So I own a company, downtown Nashville, the Hammonds Group, Inc. We're a full service real estate appraisal, real estate brokerage, investments and development firm, locally here in Nashville. I grew up in the 12th South part of Nashville. And so, I'm really understanding of individuals who I believe need a second chance. And so when Angela reached out to me, what I did, I just did my own due diligence on her. And so I reached out to a lot of people that I know in the city. And then after her story, one of the things that swayed me to even stand up on her behalf was, one, the time that has lapsed in between. And then two, the information that I got back from individuals that I know in the community about her character. And so with that being said, I just feel like, if somebody is willing to do something by themselves, and her reaching out to me was the first step. And she was really, really diligent about following up with me and following up with the commission about things that needed to get done. And so I just believe, most people, when they want to help themselves, they need access to three things. And one of those is I think people need access to information. I think people need access to capital, but I also think people need access to another opportunity. And so with that being said, that's the reason why I'm here, standing here, speaking to you guys on her behalf, because I think she needs access to another opportunity.
Thank you, sir. Questions for Mr. Hammond? Ms. Franks?
Good morning, Mr. Hammond. Could you tell me, so this Ms. Powell just called you up and you didn't know her at all?
No, I didn't. She knew we had some mutual acquaintances. So that's the first question that I asked. So once I found out how she knew me, just because I've been I grew up in Nashville all my life. So, I mean, I run across that every day, individuals that call me or talk to me and this, that, and the third that I might not have a specific dealing with. However, we did have some mutual acquaintances. So when I reached out to those individuals and then did my own due diligence, that's how I found out, everything that I needed to know about her.
And how many years have you been a principal broker?
I've been a principal broker. Ooh, good question. I was a principal broker actually at another firm. That goes back, it might be 10 years, but I actually opened up my own firm back in 2016.
Okay, the state records show that you got your broker's license in 2019.
Oh,
Is
that's
that
not true.
correct?
No, that's not true. That must be an error on the records. I've had my company since 2016.
And how many agents do you have in your office?
I believe it's 11. And then I just recently opened an office in Memphis. So if you add those, it's about 13.
Okay, and can you tell me a little bit about your training process, what that will look like for Ms. Powell?
So I've recently just hired a director of sales. And so my training process it goes basically like this. The director of sales, her name is Marquisa Beasley. She takes any new agent, not experienced agent, but new agents under their wing. And I brought her aboard. And then what I also do is I go out on all calls, the first 5 calls with all my agents, just to kind of teach them the ropes, show them the lingo, what to and what not to do. And then after that, we have meetings twice a month, every Saturday on Saturdays. And then we go over different training aspects. The meetings last for an hour and a half. And for the first 30 minutes, we usually bring an outside resource to teach some aspect of the business. And then for the remaining hour, then we basically go over some type of training material. I also require that individuals take all of the real track classes for the MLS and things of that nature. And then I also I schedule one-on-one visits with all of my agents. Kind of once they get the hang of things, I still schedule one-on-ones with them to make sure they're understanding and learning the business, and making sure the reputation of the Hammonds Group stays intact.
And so your director of sales, are they a broker?
Yes, she actually just, yes, she is.
That's all I have. Thank you.
Marcia, I was just going to correct that. He became a broker in 2014, but then did have to do a retest in 2019, which is why there was some confusion
Do
on.
Ms. Franks, do you kind of feel like you're guessing what Caitlin is saying?
A little bit. So you're saying he was licensed in 2014
As a
What-
broker.
as a broker,
And
and then
then
why did
it-
he have to retest in 2019?
It looks like the license expired, which is not relevant. I just was correcting the record that he did upgrade in 2014.
Okay, so how long have you been a principal broker at Hammond's? This is your own company, right?
This is my company. It's 100% owned by me. I'm a principal broker. I'm also a certified general appraiser.
And you've been a principal broker then at Hammond's company for how long?
Since it started, 2016.
Okay, thank you.
Other commissioners, questions? If not, is there a motion?
Motion to approve this applicant.
I have a motion by Mr. Diaz, seconded by Mr. Ferris, that this applicant, Ms. Powell, be allowed to proceed to get a real estate license. Discussion on the motion. All right, since we're ready to vote, when your name is called, if you're in favor of that motion, please vote yes. If you're opposed, please vote no. Ms. Powell, it'll take a minimum of 5 votes positive for you to proceed.
Yes, sir.
Commissioner Begley,
No.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Yes.
Commissioner Franks,
No,
Commissioner Gwen,
Yes.
Commissioner Moffett,
Yes.
Commissioner Smith,
Yes.
Commissioner Torbett,
Yes.
Chairman Grease.
Yes. All right, Ms. Powell, that motion passes. You're free to go out and be successful in the real estate business and make Mr. Hammond proud. He's taking a chance with you. I hope you appreciate that, and I hope you serve him well.
Yes, thank you so much, so very
Thanks
much.
for coming on today. Good luck to you both.
All right, thank you.
You all are you're free to stay and watch the rest of the show, or you can just go ahead and click the off button and get to work.
Absolutely.
Okay, thank you.
Thank you. Bye-bye.
All right, next up is Billy D. Featherstone Sr. Are you here, Mr. Featherstone? Great. Are you going to be talking to us today? Or is there a presentation? Gentlemen, or Mr. Featherstone, if you'd like to come up here and sit in this front row, we got a microphone right here that we may need you to speak into. While you're getting comfortable, Miss Maxwell?
Yes. Before you, you have Billy Featherstone. He was previously licensed, last licensed in 2010. You have an agreed order before you that Mr. Featherstone signed, and his license was revoked, which is why he is here before you to try to reapply.
All right, so if I can state back what I think you said. So Mr. Featherstone used to be licensed at some point in the past, which was, did you say 2009?
10.
2010. A complaint was filed against him. The result of the complaint was an agreed order that Mr. Featherstone signed that revoked his license.
Yes, and it looks like the agreed order was actually signed February 2011. We have an expiration date for the license of
Okay.
2010.
So Mr. Featherstone, we believe, is here today to talk about getting his license back.
Correct.
Is that it, Mr. Featherstone? Is that your understanding? This is well. Would you like to come to the microphone? I'll give you your floor to tell us what you think we need to know to consider your commissioners. Mr. Featherstone is here asking that his license be reinstated. That's what we're going toward, correct?
Yes, sir. Mr.
You'll give
Chairman,
us what information you'd like for us to know. And
Mr. Chairman,
yes,
I know we haven't done this in the virtual setting, but since we're in person, are we swearing in folks?
Yeah. It's
Yes,
an
sir, we do.
informal appearance. Do you need to swear him in?
Sure.
He's swearing in front of
Mr. Featherstone, you may have noticed that I can't hear very well, so if you're comfortable, you can take your mask off. Maybe I can hear a little bit better. Thank you. So you have the floor.
Okay, I had been a broker at that point for about 1980 until I had been a principal broker. Never had a complaint before. I had never had a violation. I'd never been to the real estate commission before. So when I got there, I didn't actually know what it was all about. And the attorney for the real estate commission was pressing me to do whatever because her intent was to revoke my license. Okay, and Ms. Maxwell, which was the executive director at that point in time, she did not really agree to it. But I see I was caught in the middle. It was a judge there that day, and I thought I was coming for a hearing to see what the complaint was and all the problems. So at the end of the day, I said the best thing for me to do is just surrender my license. So I did that day because I had so many problems going on personally. I had a wife that was in intensive care. I had a son that is a surviving cancer patient, and he was requiring so much of my time. The wife was requiring time, and I just couldn't keep all the balls up in there. So I said, I just need to relieve myself, surrender my license, and I can always come back and try to get the license again. But if I lose my family, it's gone for life. So I just had to make the decision what was important personally that day.
So I'm going to ask our counsel in just a second whether we have any latitude in this at all. Your request is to get your principal broker's license back. Is that what you'd like to do?
That's what I would like to do, yes.
Okay. Ms. Matlock, what options do we have as a commission?
Sure. So one of the reasons that this is coming before you is because you'll read in the agreed order, I think it says that his license was permanently revoked. That is an error. We're not allowed to permanently revoke anyone's license because it's a property right. So that's just me giving some context. So Mr. Featherstone is here to have his license reinstated. It is the commission's decision whether they would like to reinstate him as an affiliate broker, a broker, or a principal broker. There are no specific parameters for this for him to be reinstated. So those are your options if you choose to, but also there is the option of not permitting him to reinstate his license. And so if he was denied today, he would have to wait 6 months before coming back to apply again.
So the commission's options are to say, no, we're not going to let you reinstate your license. Number two, say you can now become an affiliate licensee or broker or principal broker. In none of those cases is he required to go back and take a test or do anything like that. Or we have that option as well.
I think that would definitely be an option since his license, it's been 10 years. I would recommend testing of some kind.
Once a license has been expired over a year, the law and the rule requires retest.
So at a minimum, based on what you all are telling me, Mr. Featherstone is going to have to take a test.
Yes, once you're expired over a year.
Because the license wasn't expired so much as it's revoked. Does that make a difference?
Right, so his license has not been active for a year either way. So he would have to retest. If he were to be approved today and test, he would have 6 months to do that because 6 months is the duration that the test is good for.
Okay, commissioners, now questions. I think I understand, Mr. Featherstone, did you hear what these ladies said?
Yes, sir.
So at a minimum, we're talking about you taking a test before you get your license back. I'm not sure that's what you came here to hear, but that's what it sounds like we've got to start with.
Well, I heard that, but I'm not comparing cases. But the first case, she did not have to do any test or anything. And I'm wondering what differentiates me from first case.
She's not, the first case didn't have a license ever before.
He does have to take a test.
Yeah, she will have to take a test though.
Okay, all right.
Yeah.
Okay.
Okay, so I think that's the basis where we start from. Commissioners, let's discuss this. Marcia, you want to start it?
So I'm wondering, so you signed this agreed order that we have before us.
I don't know what it says,
It's
because commission didn't send me anything in advance, so I don't know what it says.
well, they always send you stuff in advance, and especially if you have a hearing and a judge is there. So they definitely contacted you, I'm sure about
I
that.
think he's talking about today's meeting.
Today,
Oh, today's meeting?
yes.
Okay, I guess what I'm wanting to know is, so it looks like the crimes that were committed were that were earnest money accounts. Is that correct?
Yes,
Okay, and so how many were there? Do you remember? How many counts there were?
one.
Okay, so I've got like 23 things here. So are you asking that you get your principal broker's license back?
Yes.
Okay, so I think since he's not had a license in so long, that the appropriate thing would be for him to start all over and test for the affiliate license. And because of the egregious things that have happened, and it has to all do with money and escrow accounts and holding money of other persons, that I think he needs to start back as an affiliate and work his way back up.
I'm curious, what have you been doing? What's been your vocation for the last 10 years?
I was executive director for the Center for Southern Folklore up in 2007. And when it went, out since then, I've just been basically doing retirement.
So you have not had experience in the real estate market or,
Have not done any real estate. Now, what I have had experience in is basically all phases of real estate, because I'm a real estate major from college.
okay,
Major in real estate finance and insurance.
okay,
I had all licenses. I had a insurance and finance license also. So you don't have any of those complaints on any of my other licenses. So what happened with something like the economy was last year, and it just started tumbling and everything just went haywire. And when I got caught up, I just had to try to fight to come from under, because I had so many personal medical problems. I just wasn't functioning properly at that time. So I said, the best thing for me to do is come out of this, leave it alone, and then come back another day. So that's why I waited this time to even attempt to come back.
Sure. Thank you.
So what company, do you own a real estate company?
I did at that time.
But you don't own it now?
No,
Okay, so if you're wanting your principal broker's license, what company are you wanting the principal broker's license for?
okay. I don't have to have a principal broker license. I can understand that. But I would like to get the broker's license back. And if I was going to take a test, take the test for the broker's license.
So let me ask a question.
Now, I have a principal broker here with me, Mr. Harold Moore. So I'm willing to work under him, but I would like from the test for the broker's license.
I think the problem comes that the day you get your broker's license, you can become a principal broker as soon as you get your broker's license. And so that would put you in charge of escrow account again. Is your intent to sell real estate, or are you wanting to manage a real estate business?
I don't want this street again selling. I would love to manage a real estate company. I have participated in a nonprofit for years, the Home Ownership Foundation. So I do more education and training workshops and that type stuff than sales. And I created Home Buyers Education in Memphis, Tennessee. So I'm the one that got that started. I was consultant for United Way for 6 years to get United Housing started. If anybody ever heard of that, I was the person that was instrumental in starting United Housing. So my knowledge of real estate goes much further than selling a home.
Marcia, at one point, I thought you were on the verge of making a motion. Did I
Mr. Chair.
misinterpret?
Anybody else got any questions?
Jeff?
Yeah, I just want to ask council, do we have any history at all about why there were so many sections cited in the order? Like, it seems like the offense was related to an escrow account, but it seems that there's a lot of sections in there that are cited that we don't typically cite now for a similar offense. And I'm just wondering if that was practiced then or.
This was in 2011, so I can't
Right.
really speak to it, but I would assume that I'm looking at the sections that were cited. They all seem to be related to the earnest money issue. So we have the substantial and willful representation. It's really just kind of like a decision that the attorney who drafted it makes a decision regarding which matters to cite in the agreed order. Also, it may be that Mr. Featherstone at the time was represented by an attorney. So it is agreed order, so it may be a decision that was made among the parties. I don't think that any of the particular citations here veer off from the substantive issue of what we're talking about. It may be that they just cited multiple things because multiple things apply.
So one of the things too that was stipulated in this document was that you were suspended for a minimum of 2-year period or until all terms of this agreed order have been satisfied. And those are, have you taken the 16 hours of continuing education in ethics?
No, I have not had.
Okay. Have you taken the 16 hours of continuing education in property management?
No.
Have you taken the 16 hours of continuing education in writing prior to reinstatement? Contract writing?
No.
Okay. Have you paid the $5,000 penalty?
Well, see, when I requested this hearing, I asked Mr. Smith, was it anything I need to know of in advance? And he said no.
Who's Mr. Smith?
The one who schedules the hearing.
Aaron.
Oh, okay, Aaron.
So,
Okay, but you signed this order and it tells you that you can't come before us until you've satisfied these things. And now you're telling me you haven't satisfied any of them? Is that correct, Anna? If you look under stipulated disposition?
Right, I'm checking on that to see what we have. In so the information for this particular matter was not it's not in our database. So I'm trying to look because it's so old. But we pulled this record from the Administrative Procedures Division. So I want to see really quickly on his licensure profile what we have and what we don't have.
Okay.
Anna, just to be clear, is this it's just one charge? It's just one instance of earnest money?
There are 3 different docket numbers on the agreed citation, on the agreed order. So I would assume that there would be 3 matters.
now is those my sons or my personal ones?
They're combined. So if you look on the agreed order that we have, you'll see 2 respondents, Mr. Featherstone Sr. and Mr. Featherstone Jr. How it's written, it's delineated by name, what's under it. So I do not think that what we're talking about today would be the matters for your son.
Because he was not the principal broker in charge of the escrow accounts, right?
Correct.
Mr. Featherstone, do you want to just tell us what happened exactly? Because I'm still trying to figure this out.
Yeah, I don't think any of the commissioners from 2011 are here.
Pardon?
So just tell us the
Just
story.
tell us what happened to get you before the commission the first time when you got your license
Well,
revoked.
I went before the commission because of complaints that I received on my son. Okay? And the individuals were there that day that had complained. I had taken the money with me in a cashier's check to remit. The attorney for the commission said, we're not going to take any money. we're going to revoke the license and we don't want the money. Okay? And they wouldn't accept any money. Okay, so that's what got it started. Now, my particular situation came after that day. So, you know, I've made every effort to give the money over to the individuals who were there that day. They would not let me give them the money. The commissioner wouldn't take the money. And they told me I got to come back with a lawyer and I need to pay $600 for these individuals to come to Nashville for that day and wasted their time. Well, I had to pay $600. So I went through all of that. And it just got to the point of so overbearing, I couldn't keep going. So that's when I just dropped out.
And according to these documents, what happened was that they took earnest money from someone and the sale didn't go through and they didn't return the earnest money to the people for as long as 1.5 years. They didn't return
So
the
it's
money.
3 different times, or is it all one time with 3 different charges in the one time?
So I'll kind of help us go through this. So if you'll look on page 11 of the document where it says like starting for the page 10, it's page 10 of the actual agreed order, 11 of the document. So if you see where the stipulations of facts, so the paragraph that you'll want to begin with is paragraph 3, and then the paragraph 3 through 15 are going to describe to you the different transactions that are at question here. Paragraph 16 states that the complainant was told on each occasion that the monies were placed in the escrow account. And then paragraph 17 states that there was not an escrow account. And then the complainant requested a full accounting of the money, and we didn't have proof that any of the money was deposited in the account. So I think if you follow through those, you'll be able to see a better picture and how much is at question here.
Mr. Featherstone, did your son lose his license? What were the
We surrendered both of them that
both
day.
of you did?
And
Well,
what,
like I said, my son was recovering from cancer,
Sure.
you know, and he couldn't take the stress and strain of it either. And thinking back, I understand what may have happened to some of the money. His anti-rejection drugs was 15 grand a year. No, just to survive, just to live. And he did not have insurance to cover that 15,000. So I understand after the fact what participated in it happening, but that didn't do any good that day. And nobody would listen that day. Okay? Because the attorney for the commission had already said before the hearing, she was going to revoke the license.
Well, the attorney doesn't have that authority to revoke a license. She can tell the real estate commission that would be her recommendation.
Commissioner Egwin, yes.
question? I'm confused a little bit on, I think page 6.
Okay.
And Billy Don Featherstone Jr. has nothing to do with what we're talking about today. Is that correct or not correct? Are they linked somehow? These like number 12 and 13 with talks about Social Security and some other things like that. When I was looking at this earlier, I was like, why is this here? What does that have to do with earnest money?
Right. So if you're looking at, I'm page 6 of the document.
Correct.
So page 6 of the document, if you scroll to the top and look and towards the middle, it's going to say matters related to Billy Don Featherstone Jr. So there are 2 different individuals listed in this agreed order, but we're only talking about Mr. Featherstone Sr. And so the facts that apply to him specifically are the ones that begin on page 10 of the document.
Okay, so why do you think back 10 years ago, the attorney, there were two individuals that were getting their license. Why did they put them on one document as opposed to having it totally separate?
Right. So
Because otherwise it seems to me like they're linked somehow. Maybe not.
I can't speak for the attorneys, but I'll tell you what I think. So sometimes in matters, it looks here, we had 2 respondents on each of the 3 matters. And so the individual, the attorney probably filed notice of hearing and charges against both of them. And if the matters are intertwined and very similar to each other, I don't see a reason that the matters, it's a decision if you want to try them together, if you want to try them separately. And so I think the attorney made that decision at the time. But as it was stated before, the matters are going to be different because Mr. Featherstone Sr. was a principal broker and Mr. Featherstone Jr. was an affiliate broker. So
Of him?
yes,
Under him?
they're under the same company.
Got
So if Mr. Featherstone Jr. is going to be someone that did not deposit money into the escrow account, the rules state that the principal broker is the one that's responsible for that. So that's why the 2 matters would be together.
Is Featherstone Jr. in the real estate business anymore, or is he?
No.
Okay.
No, both of their licenses were revoked at that time. And Mr. Featherstone Sr. is not, Mr. Featherstone Jr. is not here to talk about his license. So we're only speaking about Mr. Featherstone Sr.
So, Anna, just
Yes.
a technical point. I
Sure.
don't see where Mr. Featherstone Senior signed this document.
Oh, okay. So the document is signed by their attorney. So if you look on the bottom, on page 16 of the document, you'll see that it's signed by the attorney for our department, and then Mr. Jefferson is the attorney for the respondent.
So that's the same as Mr. Featherstone signed.
Correct. He was representing him during that time. He would have the authority to sign.
So when you had that hearing, Mr. Featherstone, you had an attorney with you as well.
No, I didn't know to have an attorney. And they had a sitting judge there, but the attorney for the Real Estate Commission suggested Ms. Maxwell revokes the license, the site, as soon as we showed up. She didn't want to hear anything I had to say. So my decision, I say, well, I'll just surrender the license. We surrendered both our license there at the hearing. We did not complete a hearing.
So it was before you went before the judge? You did
No,
that?
she was there.
No, but you had not, the hearing had not started and you made that decision before the hearing?
Yes.
So who is this Mr. Jefferson Jr. then?
Who is whose son?
No, that's
the attorney.
Oh,
I mean, who is Albert Jefferson Jr.?
That was the attorney that we got after we left there to answer the complaint that the Real Estate Commission sent us after that, because we surrendered our license. So in an effort to try to keep from getting the license revoked, we answered the complaint.
and your attorney didn't tell you the difference in revoke and suspended and?
No, ma'am.
So what you're.
I have a question, John.
Joe, go ahead.
Okay. Yes, sir. Do you remember back when you were running your firm, did you have an escrow account at the time of this incident?
I did not, because I had filed bankruptcy.
So you're saying that you went to school for real estate and you had a broker license for that long? And
Yes, sir, I understand all of that, but I was going through.
yeah,
some-
okay. Well, I mean, it seems to me, let me speak just 1 second. It seems to me like you're putting the blame on the commission and a judge and the attorney. You didn't know what was going on, but you were clear that you needed an escrow account. I mean, you're clear that you were in the wrong. Is that right or wrong? Or do you think that
Yes,
you
sir.
got?
Yes, sir.
Okay.
I'm not disputing that. That was wrong.
Well, it just seems like you're saying that you showed up and it was confusing and too overbearing, and that it was you were kind of pressured by the commission and judges
Would
and
not
stuff.
believe how that day went. Nobody would believe how that day went. And I just couldn't understand it taking a turn, but when you're here and something takes a turn, you just got here in the middle of it.
Commissioner Torbett.
Did you ever have an escrow account? You said it was closed due to
Yes,
bankruptcy, so you did have an escrow
Yes,
account.
ma'am.
At what point was that closed? In relation to this matter, when was the escrow account closed?
Probably less than 6 months.
Okay.
So, banks wouldn't give me another one. So, but the commissioner told me after the fact, I could have came to them and they would allow the bank to open another account for me.
So I'd like to make a motion.
Okay, Ms. Franks.
I'd like to make a motion that we deny Mr. Featherstone's request because the stipulations, the stipulated disposition, those have not been met, the education requirements, nor has he paid the civil penalty. And that we just deny his request.
Ma'am, could I ask?
Let me see, Mr. Featherstone, 1 second. Is there a second to the motion? Last call. Is there a second to Ms. Frank's motion? All right, that motion dies for lack of a second. Now the floor is open for another motion. We'll let you speak once we have something to talk about, okay? Is
I'll
there
make a motion. I'll make
Who
a
said
motion,
it?
John.
Okay, Joe.
I would like to make a motion that we let Mr. Featherstone go through the process of getting an affiliate broker's license like any new licensee would, and he would be an affiliate broker, and he could work under someone. He has to meet the stipulations that were in this first disposition before and satisfy those requirements that were stated in the earlier disposition, and then he could sit for the affiliate broker.
Second.
Okay, I have a motion by Mr. Bagley, seconded by Ms. Franks. I'll try to restate the motion. The motion, as I understand it, is to allow Mr. Featherstone Sr. to sit for the affiliate broker's license at the point or after the time he has completed 16 hours of continuing education in ethics, 16 hours of continuing education in property management, and 16 hours of continuing education in contract writing, as well as pay the civil penalty of $5,000 that was stipulated in the agreed order back in 2011. Is that your motion, Joe?
Yes.
Is that your second?
Yes.
All right, discussion on the motion. Steve?
I'd like to think about adding a little more education onto that list, because in 10 years, there's a lot of things that have happened regarding technology, internet, advertising, those kind of things that we see a lot of cases on. I don't know if there's a course that kind of
Well, he'll be
specific-
required to take those hours to become an affiliate licensee. To sit for the test, he's going to have to take those courses.
That's not part of the motion right at the moment.
Oh, it's not?
No, not at the moment.
Just to let him sit for the test. Joe, is that your motion?
My motion is to take the hours that John just spoke about, plus he'll have to take all the hours prior. He's just like a new licensee. He has to sit through the classes and get his hours and
So
then
he'll
take
have
the
a
affiliate
license.
broker test.
Okay, so that, which would include marketing, okay.
Okay, discussion. Stacy?
I just have a problem with that civil penalty of $5,000. It seems,
Come to the microphone.
sorry, I've got a problem with the civil penalty of $5,000. That just seems excessive to me in the cases that we've heard. It's uncommon that we've gotten the civil penalty up to $5,000.
It could have been 5 counts, $1,000 each.
So
And none of
Cal-
us were here then, so we don't know.
Right.
Council, what's our authority here? Can we nullify anything that's in this order?
So, the information that's provided in the order, technically, for the amount of civil penalty, it says that should this penalty not be paid within 2 years, respondent's license shall remain suspended until all monies have been paid. it's obviously been past 2 years. I do think the commission has discretion to amend that amount. I do think you also have discretion to have that amount paid over a longer period of time, if that was also something that you would like to do. And I do think, and I'm just for context for the amount, if you look at the facts that we were stating before, I believe the amounts of money add up to $5,000.
I think I need to at least, I apologize, but I think I need to at least get some context. This is Tony Glandorf, one of the chief counsels for the regulatory boards. I don't have a document in front of me, but I have some concern over a previous order of that age that's been signed by all the parties, including the gentleman here today, that lists a certain amount of money to be owed, and whether or not the commission could just waive some of that money away, because if it had not been collected, it's possible that an amount such as this is in our collections process. And that's something that we could check on, but it's quite possible that that amount hadn't been paid. It's already been turned over to a collection agency for collections.
Anna?
So, Mr. Glandorf, is it your suggestion that we don't have any latitude with that penalty?
I think if you could definitely, if there's an amount owed, there's definitely the ability to come up with a term to make a payment plan on that term, such as terms for the payment of that. You can do that. If there is a total amount that's already been assessed at a prior formal hearing or previously agreed to, I would recommend not to change that amount, for the fact that it was already agreed to and authorized by a previous board, and that is the amount that was owed. Is that a final order that's in front of you, Anna?
Hey, Tony, I just sent it to you via email. It's an agreed order, so it did not go to hearing.
Okay.
It looks like it's an order that Robin came up with with the attorney. So, to my knowledge, the $5,000 has not been paid, which is why the license would still be in the revoked or suspended status. I don't have any documentation that has been paid to the state.
Mr. Featherstone?
And is it the commission's wish to decrease that amount that's owed
Sir,
now?
what were the penalties for? What was I paying for? Who was the money going to?
The state of Tennessee.
Right. So if you would,
You know, I'm not trying to be ridiculous, but, you know, if you tell me I do something and the penalty is X number of dollars, I can understand it. But if you don't tell me and then you make this up after I leave here today, then I didn't know it.
Your attorney signed it, you knew it.
No, I mean, I agree. This is Tony Glandorf again. I agree that this is a proper order that was already entered. It was signed by the attorney for both respondents, Mr. Featherstone Sr., Mr. Featherstone Jr. If that's something that he doesn't agree to, that's an issue that he would need to take up with his previous attorney.
All right, thank you, Tony.
And
Well-
actually, he's not even here asking for an affiliate license. He's asking that his broker license be reinstated.
We have latitude.
You know, I would take an affiliate license. I'm not, you know, all I want to do is get back in real estate.
Well, but I mean,
I have no problem with taking tests. I have no problem with taking courses. If you look at my records, my educational record, I probably got more courses than the average person you ever.
well, I have
Okay.
concerns about Mr. Featherstone's knowledge about what was happening with his license.
Me too.
I mean, he, you know, we don't have the exact visibility as to the order of events, but he's claiming that he didn't know all of this was going to happen and that his attorney signed this for him without any consultation or knowledge on his part.
And most of the people didn't work under Eve Maxwell. That's the Miss Maxwell that he's speaking of back in
Okay.
2011. I can tell you she was an attorney, and I can tell you she was very thorough.
Right.
And she wouldn't have let this just slide and someone not understand.
Right, well, she's responsible for her conduct, but not
Right.
necessarily the attorneys that
His attorney.
claim to represent him. I mean,
Let's take about a 1-minute break while this conversation goes on.
Are you gonna go? It's gonna take more than.
Okay. But to the other Miss Maxwell.
What is it? Oh, am I related? No, I didn't know.
I didn't
though.
think Caitlin
Yeah.
would have been here that long. So young.
I, no,
well, that's true.
I do know Eve though, because, we overlap.
All right. All right, ladies and gentlemen, Anna, before I restate the motion on the floor, is there anything we should know that you've just learned or decided upon?
No, so I spoke, sorry, hold on. So I spoke to Mr. Featherstone and I explained to him the amounts that were listed in the agreed order. So there's still some question of whether the amount has been paid or not. So I'm going to send Mr. Featherstone a copy of the agreed order. His attorney at the time is no longer practicing in this particular matter. So I'm going to send him the agreed order so he can see exactly the amounts that were delineated. And then we're going to see if we have proof of that either through our collections agency or he has proof of the amount of money in the agreed order. So that's kind of
Is your recommendation to defer this?
I don't think we would to defer it. I think unless Tony were to interject, the $5,000 would still be in place, that he would have to pay that amount of money. But if he has paid it, then he wouldn't need to repay it.
But did he testify that he has not paid it?
We're unsure if he has paid it or if he has not paid it. So we're going to check on that. And if he hasn't, then he will owe that money.
So at the moment, it's a requirement of the motion on the floor that he paid it. If he has that, right, that portion has been satisfied.
Correct. If it has not been satisfied, he will still owe the money. If it has, he will not.
Yeah.
Okay, so I'm going to restate the motion so we can discuss it further. Motion offered by Mr. Bagley, seconded by Ms. Franks, if passed, would require Mr. Featherstone to take pre-license courses necessary to sit for an affiliate broker's license. In addition, it would be to satisfy the requirements that were in the agreed order, which include a 16-hour course for property management, a 16-hour course for contract writing, and a 16-hour course in ethics, as well as pay a $5,000 civil penalty. That's the motion on the floor. Now discussion.
Anna, did you or Tony say, do we have latitude to change that amount?
I don't think we have latitude to change that amount because it is a past order.
Okay.
I do think that
I would, you know, I'm not disagreeing with Anna. I would, can we do, if this is going to be, if we're going to defer this anyways at another point in time, could I get more time to more thoroughly research that for the commission? Because I don't want to give you all, if you all would like to defer, I want to see if there is latitude where you all can do that. And I'm just trying to wrap my head around the authorization of a current sitting TREC commission to be able to amend an order that was issued by a prior sitting commission, and whether or not you all can undo that. And I don't want to lead you all in the incorrect direction, but this is, I've never been asked this question before, and so I'm struggling a little bit with it. My first inclination is that it was not likely be. However, I want to look at it in one more context, if I could.
So
Can I amend the motion?
No.
let me just get one
Okay.
clarification. So Tony, is it your sense that we should defer this to allow you to research it?
If you want to, if it was the commission's will to potentially change the amount of the civil penalty, then I would ask at least for more time, maybe, you know, a couple hours, that I could at least look at this and more thoroughly vet it, because I would like to see if it's the amount that we do have in collections and what that would do to us.
Chairman Grace,
Yes.
I would like, if we can defer it to June to research it, figure out the civil penalty amount, and then we'll make a determination about that. I think that would be okay. I'm still going to contact Mr. Featherstone and get him up to date of what's happening.
What if he's paid the money and has forgotten about it?
If he's paid the money and he's forgotten about it, then when we come back in June, he's not going to have to pay that amount.
It's just
If
a month delay for the Mr. Featherstone.
Right. Well, he has to retest and reapply. So I don't think he would be stopped from starting that process between now and June.
It also benefits him if that amount could be lowered. He doesn't want to pay 5,000 if we have the latitude to lower it.
So you're saying that he can start the process, even if this is deferred, he can still take the classes, he just couldn't actually get his license. So there's nothing stopping him from starting his education.
Right.
And
Right.
Okay.
Right. So since we're thinking about the civil penalty amount, that's the part that we're going to hold, and we're going to defer this whole matter. But from what I've heard today is he's going to have to retest and reapply anyway. So if that is something that he would like to do between now and June, that's possible, but we'll leave that decision up to him.
Okay. So this isn't going to put him behind in any way.
No,
He can
so
still
it's-
move forward. He just won't know if he can get his license.
Right. So like there is never going to kind of be a scenario where unless you agreed today to reinstate his license, it's going to take some time to get the pre-licensing classes, take the tests, and then these additional hours that are in the agreed order. So
Okay.
I don't think
Mr.
it
Chairman,
would delay it.
Yes, yeah.
I just want to ask Mr. Featherstone, did you consult with this attorney Jefferson at all? Did he sit down with you and go through this order and explain to you what the order read? Did you understand it when it was signed, prior to it being signed?
I had so many personal problems at that time. I relied upon him to suggest to me what to do. Okay?
So when this order was written, I'm sorry, when this order was written, he said that we have a civil order and I recommend that you let me sign it.
He
didn't go-
told me he would do it, send it back to the real estate commissioner attorney, and then get back with me. Okay? So that's why I said if I had had a copy of that, I would have known that. That was the requirement. But I never had a copy of it. She's gonna send me a copy. Now, on the $5,000, I'm not gonna let that be a hangup because once I research it, it may have already been paid.
Well, counsel, I mean, when an attorney signs an order on behalf of a licensee,
I understand.
no, I'm just, when an attorney signs an order on behalf of a licensee, do you infer that they had that consultation with their client and their
Correct.
client agreed to it?
Correct.
Is there any relief if he claims that he was not aware of the ramifications of this agreement?
Not with us.
I really don't think in this situation there would be. Since the matter was signed in 2011, we have no information to the contrary for that, but that's also something we can look at as well while we defer the matter. So,
This is Tony Glandorf. In my experience, if you have an order that's signed by somebody's attorney, that the order in itself is the four corners of the document that states what has happened. And for someone to come back and state other facts or other areas in between there, then I think the burden of proof switches back on them to prove why it is different than in the order. And I mean, in my experience, just remarks of this is not the knowledge that I had really isn't sufficient in order to convince me that something was different. There should be something more than that. Because that would open the door to allowing anybody to come before the commission and then years later create a different narrative that they are the only person that's privy to that narrative and then convince the board or the commission that the situation wasn't what it was in the past. And so that's a very difficult scenario to be in. And so generally for all orders that are signed by someone's attorney or their representative, we take it exactly as it's written, and that is the story that we've had. That's my experience is the best way to look at those.
So Joe, do you want to amend your motion to a deferral till next month? That's what we need, right?
Well, let's see, the motion on the floor right now is to act today.
Right, the motion on the
Like
floor is to
myself.
act. Let's-
Somebody might want to make a substitute motion to defer, and that would be in order.
I'd like to call the question.
Okay, we've got a motion to call the question, so at this point, we're going to vote on the motion. I want to restate the motion one more time, just make sure everyone's clear. Call for the question, stops debate, and we'll take a vote. Motion is to offer Mr. Featherstone the ability to take his affiliate broker license after completing pre-license courses, also attending, completing 3 16-hour courses, which we've listed before, as well as pay a $5,000 civil penalty. If you're in favor of that motion, when the name is called, you'll vote yes. If you're opposed, you'll vote no. He'll take 5 votes for it to pass. If you don't get 5 votes, we'll open the floor for another motion. That's where we are. Everybody clear? All right, Ms. Maxwell.
Commissioner Begley,
Yes.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Yes.
Commissioner Franks,
Yes.
Commissioner Gwynn,
No.
Commissioner Moffett,
No.
Commissioner Smith,
No.
Commissioner Torbett,
No.
Chairman Grease.
Nope. Motion fails on a 4-5 vote. Floor is open now for another motion.
I'd like to make a motion that we defer this until the June meeting.
Is there a second? Seconded by Ms. Torbett. Discussion. Yes, Steve.
I would like to ask Mr. Featherstone a question or two. So my understanding that you came in here today not knowing what this document says, is that correct?
I'm not gonna say I didn't see this document, but in my confession, I don't have a copy of it, so I wouldn't know a part of the date. Rest of the hearing, Do I need any information coming here today? No, you don't need anything. Do I need something from you to come here today? No, we're not gonna send you anything. So that's why
So I don't understand how we have the latitude then, in your opinion, to do what's different than what's stipulated here.
I have no problem with paying whatever it says. I don't have a problem with that. I'm not contesting that. Because if I've paid it, I can show you I've paid it. If I have not paid it, then I understand it has to be paid. So I'm not contesting that at all.
So if you read this and it says, respondent's license shall be suspended for a minimum 2-year period or until the terms of this agreed order have been satisfied. So the way I'm reading it, tell me if I'm wrong, Anna, is if he satisfied those stipulations beyond 2 years, then his license is no longer revoked. Is that correct or not? I mean, I'm just reading what it says.
So there was a 2-year period that was written in the order.
It says 2 years or until the terms.
Right. And so at this point, the terms haven't been satisfied. There's
It doesn't say it doesn't say 2 years or the later of. Is that what you're saying?
right. So it says, I think that Mr. Featherstone at this point does not have his license is either suspended or it's revoked, and which is why we brought it to you here today. I don't think that
If he did this, it would.
I don't think that I would put him back in that position.
So
No.
is he suspended or is he revoked?
In the system, it says that he's revoked. So that's another thing that we want to look at. It says revoked, it doesn't say suspended. So we'll look at that. I just also want to state, I don't think we knew that Mr. Featherstone didn't have a copy of the agreed order. So what we'll do is I'll get him a copy of this order. We'll come back in June. We'll talk about it. I'll get with Tony, Mark, Caitlin, and we'll figure out a better situation to figure what this is. And we'll give Mr. Featherstone time to let us know if he's paid this or not paid it. And then, or the continuing education courses, and we'll see.
So if, I don't want to belabor the point
Sure.
too much, but if he had come in here and said, here's my canceled check for $5,000 and I did these 3 things, I want my license back, we would have said no because it's beyond 2 years. Is that what you're saying?
I think we would have said no because, like I said, the issue is this order says suspended and his license says permanently revoked. I need to figure out why there's a difference.
Okay.
And that may be just an issue of how it was entered in the system when we switched over to core, or it may be that we're missing something. So I'll get back to you on that too, to see if he does satisfy those things, he would get his license back.
So if it was suspended,
Mhm.
to make sure I totally understand, if it was suspended and he did these 3 or 4 things, then no problem. He gets his license back. No
He wouldn't
testing.
be before us.
Right.
Well,
No, he would still be before you
yes.
because it falls within the 10 years. And this would be something that an occupational body issued and you would be the body, which is why he's here today. So even if his license were to be like reinstated at that point, if your scenario were to play out,
Yes.
he would still have to come before this commission because he has a matter, like the rule says, if you have any criminal conviction related to theft of money, services, or property, or any felony, or if you have discipline from any state, local, or federal occupational licensing body, you have to come before the commission. And so he would still have to come before the commission because he has a matter that falls within that 10-year look back. And so then you would make the determination at that time whether he could proceed with his license or not. So that's
Like this order already took that into account.
I
It does to me.
I don't know about the order. I just know what I know now, based on the rules and statutes, that would still be my recommendation. But we'll look and see what's going on. If it's a suspension, I still think he would have to appear before you because it falls within that 10-year look back. But if it was a revocation, then he would still have to appear before you because revocation means that the license no longer exists.
Commissioner Torbett.
Mr. Featherstone, have you taken any of those continuing education classes that were required of you?
No, ma'am, I didn't know to take them.
Okay,
So I
so
would
you,
have
you,
before-
you were unaware, that's your position, that you were unaware of any of this?
See, my license was suspended. I surrendered my license.
Okay,
They revoked them maybe later down the road, but they was suspended when I agreed.
so you were unaware of these continuing education requirements of the 3 different 16-hour courses? So
Yes,
you
ma'am.
had no idea that you were supposed to have taken those?
Correct.
Okay.
So I would have already had them before
Got
I
it.
came here today. And when I requested of the real estate commission, what do I need to know? What do I need when I come to the hearing today? They say, you don't need anything, just bring your principal broker. That's the only reason I have my principal broker here today, because that's what I was told. And I got emails to show that's what they kept telling me. And
I think the assumption was that you had a copy of this document from your own attorney.
I think he's been let down on a lot of occasions.
I
Through
agree.
this process. And so I think the way to clear it up is for us to defer it and to
Mhm.
let him get everything together, let the state get everything together so that we have the right picture of what actually needs to be done. And I think that benefits Mr. Featherstone as much as it does the state.
Okay, so the motion on the floor, as the chair recalls, is to defer this to the June meeting. And I think Ms. Franks made that motion, Ms. Torbett seconded. Is that correct?
Yeah.
Okay, is there more discussion on the motion?
I'd just like to offer some discussion. Commissioner Gwynn, I think, is tracking a thought that is, at least in my mind, I don't want to assume this, but if Mr. Featherstone has met these orders from 2011, and technically it is past the 10-year mark, if I'm right, but I don't want to get into that right now, but if he has met this, then he would have come before us, and if he'd had his cancel check, and if he'd said, I've done my education, we would have probably said, get your license back.
Correct.
And
That's,
so,
that's why I'm just reading the.
right, yeah, so and I voted a moment ago in an affirmation for an affiliate broker motion. And so I'm going to certainly vote to defer this to June, because until we all have the facts and have more of the information, then there's a chance here that you would be in a position that came here to procure in the first place.
I'd like to call for the
Okay,
question.
I've got a call for the question, sir. I see you out there and recognize that you're potentially Mr. Featherstone's. But if this motion passes, it's probably in the best interest of Mr. Featherstone. So I'd like to get this vote in before we have further discussion. It's just the opinion of the chair. Commission can say, let's hear from him or anyone else if you'd like, but no, you can't. We got a motion. We have a call for the question. So debate stops. If you're in favor of stopping discussion and deferring this until June, you'll vote yes when your name is called. If you're opposed and would like perhaps to continue discussion, you'll vote no. Caitlin?
Commissioner Begley,
Yes. Yeah.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Yes.
Commissioner Franks,
Yes,
Commissioner Gwynn,
Yes.
Commissioner Moffett,
Yes.
Commissioner Smith,
Yes.
Commissioner Torbett,
Yes.
Chairman Grease.
Yes. All right, so this motion is in order to give staff time to get us more detailed information. Tony, we appreciate your input on it. We're deferred it till June in Nashville, Mr. Featherstone. You may prefer to participate virtually like some of these people are doing today to save you from that trip.
Can I ask this? What do I need when I come in June?
You I think Ms. Matlock will.
She'll help
See,
you.
that communication,
She'll help you.
right.
You've got the right person.
Yeah, well, I'll email and call and we'll figure it out.
All right, so we're off this topic. Thank you for showing up today. Appreciate your point of view on this. We'll try to get it handled in June. But in the meantime, if you prefer to start taking classes, be our guest. because it appears to me there's going to be classwork required.
Okay, do I need to bring my principal broker next time?
I think at this point, Anna, do you see a need for that, or Tony?
I don't see a particular need for it if, let me make that decision. I'll email you.
Just
it
let
might-
him know.
Yeah, I'll let him know and then I'll let you know, Chairman Grace. We'll just add that to the conversation, but I'm thinking no, but I will give you a
Okay.
final one.
Well, you'll be advised. We don't know
Okay.
that answer at the moment. Thank you for coming
Thank you.
down today. Let's take a 10-minute break. We'll get started with the last informal appearance before we get to the Education Director's report. The time is 10:03. Let's come back at 10:13.
Sorry.
Almost immediate. From over the side.
Hey, Caitlin, why do you need our credit card information?
Hotels.
In the future,
We'll get on our credit card?
But us guys that travel, we have
Yeah.
to bill it.
It's mainly for Nashville people. We do that like to book all these rooms every month. But I mean, you don't have to.
Can I
go-
leave it alone?
Yeah, but we'll probably be calling you in October when we go to East Tennessee.
All right, it's 10:13. Let's get back in session. Next up is an informal appearance by Alexander Blesinski. Caitlin?
So we'll be presenting this on his behalf. This is a request to waive the exam. Mr. Blesinski's license expired on January 14th, 2020. So he is past the 1-year mark and asked that he be presented to the commission. He has written a letter to the commission that should be included in your documents. And he's also included a letter from his broker.
So we're considering this application under the executive order, the governor's executive order for a waiver of,
No, we are considering this because I spoke to, or our staff spoke to Mr. Blesinski, and he was not necessarily satisfied with the rule requirement and asked to be presented to the commission.
okay, so the latitude given by the governor in his executive order does not apply here?
No.
Is he appearing today?
No, I just told him that we would present these letters on his behalf.
Are those letters on the,
On the iPad.
okay,
There, yeah,
I've read them.
okay.
So he's asking that his license be reinstated.
It is on the iPad.
Is it? Okay.
Yeah.
It is.
So,
So he wants his license reinstated and a grandfathered
Without
status,
having to take the exam.
and a grandfathered status.
Yes.
What is that, affiliate broker grandfather status?
He's an affiliate broker and he's grandfathered from taking education.
When do you get grandfathered as an affiliate broker?
So educate, in the law, I believe it's around 1980. Broker is 2005. So you see it with brokers a lot more because it's later.
Say that one more time.
I have to pull up the
I didn't know
law.
affiliates were ever grandfathered. I
Yeah,
didn't know that.
they are, but you don't see it very often because,
They upgrade their license.
well, they upgrade their license or, not as many people are licensed,
From 1980.
1980.
so is this a two-part request? One, to reinstate his license, and second, to allow him to keep his grandfather status? Is that how you see this?
I guess I just assume that he would like to keep his grandfathered status, which is why he's, written this letter and requested to
So,
get his license back without
But
retesting.
maybe if he had not been grandfathered, he would have realized that he had to renew his license.
so Anna, can you tell the commission what latitude we have at this point?
Is he revoked?
Okay. So as to whether we can waive the test, retest, and reapply, we don't have any discretion that the rule says 1 year, that's it. For the matter of grandfathering, I think that's something that is up to your discretion, how it's written in the statute. So if you guys wanted to look at the particular provision we're talking about, I'll give you the page to look in. It's going to be so it's on page it's on page 28.
Yeah.
28 of your document. I'm not sure. Hold on.
It's actually 1988.
Right. So if you look, it's going to be 303, section C, and then 3. It talks about grandfathering. But Caitlin also just brought up a good point that the current rule, how it's written right now, it states if you have to retest and reapply, you have to meet the current education standards. So I think that this licensee would need to complete that, but I think you need to complete that education.
Is he a broker or an affiliate?
Affiliate.
Yeah. So my understanding was that if you let your grandfathered license expire and pass that 1 year mark, you're not able to get your grandfather status back.
Yeah, the rule says you must meet current education requirements.
So that would essentially remove your grandfathering status. So we're deciding today whether he can retest or reapply. Well, I mean, that's what it's going to have to do. But like whether we were to waive that, which you don't have discretion to do.
I'd like to make a motion that we deny Mr. Blesinski's request.
Second.
Who seconded that? Jeff, said you. Okay, the motion on the floor is to deny Mr. Blesinski's request. And the basis is we have, as I understand, Ms. Matlock's comments, we have no discretion.
Right.
The rule does not allow it. That's, am I saying that correctly? All right, discussion on the motion.
Can we please let them know also about that their grandfathering is no longer when we let them know about this?
Yes.
I think that'd be important to them.
All right, if you're in favor of the motion, which would be to deny Mr. Blesinski's request, when your name is called, you vote yes. If you're opposed, you'll vote no.
Commissioner Joe Begley,
Yes.
Commissioner Diaz,
Yes.
Commissioner Ferris,
No.
Commissioner Franks,
Yes.
Commissioner Gwynn,
Yes.
Commissioner Moffett,
Yes.
Commissioner Smith,
Yes.
Commissioner Torbett,
No.
Chairman Chris.
I'll recuse myself on this vote. What's the vote count?
It is 6 ayes, 2 noes.
The
One
motion
recusal.
passes. That item is handled. We're on now to the executive director's report. Mr. White, come to the microphone. Let us see how you look. No, go up to the, let you stand a little bit.
Thank you,
You've
Mr.
been
Chairman,
busy.
members of the
You've been
commission.
busy based on the number of courses you've got before us.
Yes, I've got my personal best as far as preparation of courses this morning. And as you look on to your iPads, I present to you M1 through M85. I present them for your approval after my review of all the providers, the courses, and the instructors.
We're not going to approve the instructors just yet.
Mr. Chairman, I move that we approve courses M1 to M85.
Mr. Diaz makes a motion to approve courses M1 through M85. Ms. Frank seconds that motion. For the audience's information, Mr. White is the education director for the Tennessee Real Estate Commission. So he should know, and I believe he does know what he's talking about when he makes this recommendation. Is there a course or courses that commissioners would like to pull out before we vote? All right, we're ready to vote. If you're in favor of the motion, and which is to accept the recommendation of the education director and approve courses M1 through M85, you'll vote yes when your name is called. If you're opposed, please vote no.
Commissioner Beckley,
Yes.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Yes.
Commissioner Franks,
Yes.
Commissioner Gwen,
Yes.
Commissioner Moffett,
Yes.
Commissioner Smith,
Yes.
Commissioner Torbett,
Yes.
Chairman Grease.
Yes. So that motion passes unanimously. We have a lot of confidence in you, Mr. White, for us to approve 85 courses in one vote.
Thank you, Mr. Chairman, members of the commission. I appreciate that vote of confidence as well.
All right, what about these three instructors? What do you recommend on them?
With three instructors this morning, again, they're before you for your approval. I find them to meet all the rules and the laws pertaining to the instructors.
Motion to approve these instructors.
Second.
Mr. Diaz makes a motion, and Ms. Smith seconds that motion that the education director's recommendation be adopted and these three instructors be approved to teach. Any discussion? When your name is called, if you're in favor of the motion, vote yes. If you're opposed, vote no.
Commissioner Beckley,
Yes.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Yes.
Commissioner Franks,
Yes.
Commissioner Gwen,
Yes.
Commissioner Moffett,
Yes.
Commissioner Smith,
Yes.
Commissioner Torbett,
Yes.
Chairman Grease.
Yes. So that motion also passes unanimously, Ross. You're 2 for 2.
Thank you, Mr. Chairman, members of the commission today.
Anything else for us today?
I do not. I appreciate the vote of confidence and being here with you today, and I just hope everybody has a safe trip home.
Thank you, and we appreciate the workload you took on.
Thank you so much.
All right, next up is Ms. Maxwell's report.
Okay, I don't have a huge update for the commission. But I did want to let them know, I know I mentioned last time we were working through some issues with PSI. A lot of those seem to be resolved. We're continuing to work through some of the issues and add additional information where necessary. Some of the issues we were having were people connecting with their proctor in the remote arena, which should never happen. There's always a proctor available when you're taking the test remotely. So we're including some additional information and spots there for that. And then PSI has promised me some updated material to send providers so that it answers some of the common questions that we've been receiving over the last month. So we're working on a couple things there with PSI that I think will hopefully resolve a lot of the issues that we have had. In addition, legal is continuing to work through all of the E&O suspensions. We have a lot of principal brokers that do not want to pay or satisfy their complaint when their affiliate has failed to maintain E&O. But legal is working through all of those with lots of patience. And otherwise, it has been business as usual.
So just a couple questions. So if I understand, when the affiliate fails to pay, buy insurance, at some point we open up a complaint against the principal broker. And that complaint involves, to satisfy that complaint, you got to pay some money, right? And
Yes.
the longer you go without paying it, the more you have to pay.
Yes.
And there are brokers who don't understand that concept. And what do they think will happen? Do they think they can come to us and we'll just go, we agree with you?
Chairman, most of them are thinking that they can get some sort of a waiver because they didn't know or various other reasons.
So just for the record, we'd be glad to pass a motion that says they're not going to get a waiver if that would help you at all. What do they need to get this resolved? They just think they're going to blow it off?
I just remind them that this is statutory and there is no waiver available.
And do they sometimes come around at that point, or there's some that'll still try to fight you?
Yes, sir, they do.
There's
but
still some that
still fight. Yeah.
They're realtors. Well, they're not even realtors necessarily, licensees.
Everything's a negotiation, right?
Yeah.
So, Caitlin,
Didn't hurt to ask, right?
you're comfortable we'll meet in person in Nashville next month?
Yes, the EO has been lifted, and so unless, anything crazy happens between now and next month, we will be in Nashville.
Because we could always go back to Jackson, I guess.
Yay.
So, Anna, do you know if we have a formal hearing next month?
No, not at this time, so, no.
But we could still have one. But it's like 30 days out, we'd know. Something.
Yeah, it just depends on the date, but I don't think that.
Okay.
I believe the date is the 10th. I think we're meeting June 9th and 10th.
So unless Shalina files something today, then
In the next, yeah, in the next couple of.
All right. Yeah. Other questions for Caitlin? If not, thanks for the report.
Yep.
We'll move on to the consent agenda, legal consent agenda. For the audience's information, we have 60-some cases today, plus one that was added late, right?
Yes, sir.
So we have 66 plus one. In each of those cases, council has recommendations that council has made to us about the disposition of those cases. And many times, this commission agrees totally with what council recommends. And so we have a consent agenda that will take care of most of those 66 cases plus one. The commission also has the latitude to pull particular cases out of the list of 66 cases and say, I need a little bit more discussion on it. So in a moment, you're going to hear a motion to approve cases 1 through 66 with the exception of about a dozen cases, maybe 11 cases, and then we'll talk about those cases individually. Let me tell you, repeat, most of you people know this, we have no idea who we're talking about, what company they're with, what part of the state they work in. It's been totally, it's not the right word, but anonymized. What is the right word?
Redacted.
You made that up.
Redacted, that's it. So
Like anonymous.
I think it's a good word.
It's a good word.
It's a spelling bee word.
Won't work in Scrabble.
Can you
Won't
use
work in Scrabble.
All right, so Shalina Brown is a litigator with the state of Tennessee, Department of Commerce, Insurance. She's sitting right here. She'll be presenting the cases to us on behalf of the department. We'll have questions for her, and sometimes we'll agree with what she suggests, and sometimes we won't. But we do respect her professionalism, and she respects our experience in the field, I'm sure. I hope. Here we go. Shalina, what do we have for us today?
I believe you have the May 2021 consent agenda. You also have a listing of all of the cases in your packet of material. And I believe there are certain ones that have been pulled out.
Okay, so the chair will entertain a motion that will, if passed, approve council's recommendation on cases 1 through 66, with the exception of cases that have been identified previous to this meeting. Those cases that I have on my list are case 7, 12, 24, 31, 34, 41, 44, 45, 53, 55, and 66.
So moved.
Let me see, does anybody else have any other cases that want to pull out? If not, I'll accept Jeff Smith's motion. Is there a second? Second by DJ. So the motion on the floor is to accept cases 1 through 6, council's recommendation on cases 1 through 66 with the exception of the cases I just itemized. If you're in favor of that motion, when your name is called, you'll vote yes. If you're opposed, you'll vote no. Caitlin?
Commissioner Begley,
Aye.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Yes.
Commissioner Franks,
Aye. Oh, yes.
Commissioner Gwynn,
Yes.
Commissioner Moffett,
Yes.
Commissioner Smith,
Yes.
Commissioner Torbett,
Yes.
Commissioner Chairman Grease.
Yes. All right, so we just handled about, say, 54 cases. Now we're on to case number 7. That case was pulled by Commissioner Franks. You guys will find that in your list, either on your iPad or your printed version, if you have one. And Marcia, if you'll tell us what you think about this.
Okay, so this is the one that was a company that represented new home construction. And it was opened against the firm. And this person, I mean, they say that they didn't know that they had to be licensed. So I'm thinking that the complaint actually, that we need to open a complaint against the person and the principal broker, not just the firm, because they have been doing unlicensed activity. And this is like a big topic all over the United States about there's some new home contractors that don't believe that they have to have licensed people selling their products. So this is an out-of-state company that has someone in Tennessee representing them. And I think it's a place that we need to do more than just send a letter of warning, because I think that big company, wherever it is, I don't even know what state it's from, will just put it in their file. They don't have to pay a penalty or anything. What I'd like to hear from is I'd like to hear from the person who's doing the unlicensed activity and their principal broker.
Commissioner Franks, let me just clarify. This firm is licensed, and it is a subsidiary of a larger parent company that is operating in Tennessee. It's not an unlicensed, it's a issue concerning the advertising rules. The complaint was made by an affiliate broker stating that the name and the company were not, name, company, and phone number were not appearing on the listing that this firm was posting those listings. Actually, what happened was it was properly posted, and for some reason, there must have been some glitch. The complainant was not able to see that information, but it was there. They have confirmed that with the parent. So although the complaint was made against the subsidiary, the complaint should actually be against the parent, and they are properly listing all the information as required under the advertising rules. That's why my recommendation is for a letter.
I'm looking for the person who did the advertising without putting the name of the company and phone number. That's who I'm looking at. And then that leads me to the principal broker. So it's not about the firm. The firm, there's no one that's a firm. The firm is an entity. So I would like, I'm more interested in the people who are getting around these kind of things. So I'm interested in, is the person who did this a licensed person in Tennessee?
Yes, this subsidiary does have a licensed person.
And a licensed principal broker?
Yes.
And Shalina, did you say that the advertisement was in fact correct? Just wasn't visible to the affiliate or whoever filed this complaint?
Yes, at the time the affiliate pulled it up, it was not appearing for some reason, but they have checked their system and it is there.
Have you checked the system and
Yes.
see that it's there?
So why shouldn't we just dismiss this complaint?
If it's the will of the commission, sure.
Well, I thank you. Well, okay, in that case, what if we fine them $10,000?
Yeah, and it's against the firm, so you can't give them education. The only thing you can do is a monetary on a firm.
Yeah, but if our attorney says that the advertisement was indeed correct.
I move to dismiss this.
Second.
Motion by Mr. Ferris, seconded by Ms. Torbett, that this complaint be dismissed. Discussion? If you're in favor of that motion, when your name is called, you'll vote yes. If you're opposed, please vote no.
Commissioner Begley,
Yes.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Yes.
Commissioner Franks,
No.
Commissioner Gwynn,
Yes.
Commissioner Moffett,
Yes.
Commissioner Smith,
Yes.
Commissioner Torbett,
Yes.
Chairman Grease.
Yes. That motion passes. We're on to case number 12. DJ, he's pulled this one.
Thank you, Chairman. I pulled this one because I wanted to make a motion to just reduce the recommendation of $1,000 civil penalty to $500. I do believe the respondent has some responsibility to know what's going on with their clients. However, we just don't know where they are where they are at all times and what agreements they're making with son-in-laws and of sellers and properties and agreements and what's shared and what is approved about moving in a home and otherwise. And so that would be my motion and why I pulled case number 12.
Okay, so Mr. Ferris is offering a motion that would accept council's recommendation with the exception of the civil penalty, which would go from $1,000 to $500. Is there a second to that motion?
Second.
Seconded by Mr. Diaz. Now discussion. Steve?
How'd you come up with the number?
I divided it by 2.
Got it. All right.
Realtors are quick with numbers.
I used my math skills. Good question.
So that I understand the case, the allegation is that an agent gave possession to his or her buyer without the permission of the seller.
Gave them the lockbox code.
That's the allegation.
That's pretty egregious.
Yes.
Well, the complainant,
That's like breaking and entering.
I thought knew that.
I think the complaint didn't know it, they wouldn't have filed it, is what I think.
The
And I
complainant,
think he thought it was egregious enough to have $1,000 civil penalty.
you make a good point. The document says the complainant
Errors on
agreed.
the other side, so that, to me, sounds serious.
And it was a son-in-law.
There,
There you have it.
so,
There you go.
so we don't get too sidetracked. Mr. Ferris's motion is on the floor for discussion. If you're ready to vote on the motion or offer a substitute motion, the chair will entertain that, but we need to keep moving. So
I'd like to offer a substitute motion
Ms.
that we
Franks?
accept council's recommendation and that the civil penalty be $1,000.
is there a second to that? Seconded by John Moffett. Discussion on that motion. Procedurally, if the substitute motion passes, we're done with this topic. If it fails, we'll go back to the original motion Mr. Ferris offered. Discussion. If you're in favor of Ms. Frank's motion to accept council's recommendation and keep the civil penalty at $1,000, we'll vote yes. If you're opposed, you'll vote no. When your name is called. Caitlin?
Commissioner Begley,
Yes.
Commissioner Diaz,
Yes.
Commissioner Ferris,
No.
Commissioner Franks,
Yes.
Commissioner Gwynn,
Yes.
Commissioner Moffett,
Yes.
Commissioner Smith,
Yes.
Commissioner Torbett,
Yes.
Chairman Grease.
Yes. All right, that motion passes. We're on now to case number 24, offered, pulled by Ms. Franks. Marcia?
This is the one that had a billboard that was not in compliance. And the recommendation was for a consent order of a $500 penalty for the advertising violation. It didn't have the firm name or firm phone number as listed by the commission. And their name appeared much larger than, I don't even know if the firm name was even on. But anyhow, so I'm wondering why it was $500 and not $1,000, is which we typically give. And to me, when it's a billboard, billboards are usually in high traffic areas, so more people are going to see them. It's more than just a sign out in the front yard of a listing. So that's why I gave more credence to this violation being a billboard. And I also thought that that we should have a civil penalty for the affiliate broker of $1,000, and to also open a complaint of the principal broker because they're in charge of the advertising. And if it's a billboard, it's not like it was a social media post that was hidden somewhere in their Facebook page. It's out on a major highway, most likely.
Okay, I'm gonna hope to get us two motions based on what you said. Does anybody want to second Marcia's motion about the $1,000 civil penalty instead of 500? Let's start with that.
I'll second it.
I've got a second. I've had the second, so that motion is properly on the floor. Then we'll come to this after the first vote, but Ms. Franks is also suggesting administratively we should open up an complaint against the principal broker for failure to supervise. Does anybody want to make a motion to that? Second that.
There typically is one automatically opened. Do you know if we know in this case if there was?
I don't believe there has been one.
Okay.
So is there a second to the motion?
The second motion or?
The second motion.
Oh.
We're gonna vote on these separately. But
I think she said.
well, let's come.
Take them separately.
Well, we're going to take them separately. Let's, as a matter of fact, I'm going to withdraw your motion
Yeah.
shortly. The only motion on the floor at this point is to accept council's recommendation with the exception of the civil penalty and increase it from $500 to $1,000. That's properly on the floor. Is there further discussion on that motion? Let's vote. And when your name is called, if you're in favor of that motion, you vote yes. If you're opposed, vote no. By the way, is this the first complaint, advertising complaint against this particular respondent?
Yes, sir.
Okay.
Commissioner Begley,
Yes.
Commissioner Diaz,
Yes.
Commissioner Ferris,
No.
Commissioner Franks,
Yes.
Commissioner Gwynn,
No.
Commissioner Moffett,
Yes.
Commissioner Smith,
Yes.
Commissioner Torbett,
No.
Chairman Grease.
No. So that motion passes on a 5-4 vote. Is that correct? Okay.
Yes.
Yes.
Okay, so we're on next to number 31. DJ?
What's up, Chairman? Thank you. Chairman, I admit this should have been included in the 54 other cases, so I had it pulled.
So your motion is to dismiss per
Motion,
council's.
yes.
Is there a second?
Yes. and to
That's
approve-
not,
Steve Gwynn,
No,
second.
my motion is to accept council's recommendation.
yeah, it's
Oh,
not
yeah,
to be
yeah.
dismissed.
My fault.
Okay.
You're correct. Absolutely. We're going to accept council's recommendation if this passes. If you're in favor of the motion, your name is called, vote yes. If you're opposed, vote no. Caitlin?
Commissioner Begley,
Yes.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Yes.
Commissioner Franks,
Yes.
Commissioner Gwynn,
Yes.
Commissioner Moffett,
Yes.
Commissioner Smith,
Yes.
Commissioner Torbett,
Yes.
Chairman Grease.
Yes. That motion passes. We're on to case number 34. Three members of this commission pulled this case. I'm going to start with DJ. You want to tell us about this one?
I pulled it because of wanting to hear from council more about the complainant's remarks about offering non-licensees monetary rewards if the individual bring the respondent a seller. Did anybody else catch that who pulled the case, or I'd be interested to hear why you had asked for it to be pulled.
Marcia, you want to speak?
I pulled it because the only new information that we have is that the complainant contacted our office and has resolved all the issues related to the complainant. But that doesn't mean that they didn't violate the code. And they violated, this was one that was for $4,000. So that tells me they violated 4 4 items, because we can't authorize anything over $1,000. So I pulled it because I see no reason to change our original decision. None of the facts have changed.
So I prefer to pull it. I pulled it for 2 reasons. In the new recommendation, it doesn't speak to a civil penalty. I assume it's $1,000, but it doesn't say that in the new recommendation.
Yes, sir, it's 1,000, I'm sorry.
Okay, and second of all, I also agree with Marcia. What changed on the other 3 civil penalties that we offered? I know the complainant is satisfied, but does that mean that the respondent didn't do them? Or just because the complaint is satisfied, we're going to drop a few charges?
Well, this matter, the consent order was sent to the respondent. The respondent has requested reconsideration. And the main reason here that I have amended my recommendation is because this complainant is no longer willing to cooperate and participate. So in order for me to prove these allegations, it would be somewhat difficult. The complainant has also been made whole. So I have some concerns about that. And based on that, I felt that I could go forward with the one violation for engaging in self-dealing. And as to Commissioner Farris's comment, the allegation was that this respondent was offering non-licensees a monetary reward. However, I did not have any evidence or information about that.
Okay.
But you did before, obviously.
I had the.
Was this your case?
Yes, I had the complainant's remarks, but it didn't necessarily, the violations were not connected to the monetary rewards being offered by the respondent. It was related to the money that was invested with this respondent.
This is one of those, it's easier to get forgiven than to get permission. And I just feel like that this person, obviously, we assessed them $4,000, so we thought that it was pretty important when we did that. And none of the evidence has really changed. It's just the complainant is, has resolved all issues related to the complainant. But it doesn't change the charges of the violations.
Are you saying that your evidence was mostly based on the complainant's testimony?
Yes, that's the main issue.
And since the complainant is no longer willing to testify, a
Right.
formal hearing would be a hard
Be an uphill battle.
for you?
Yes.
Well, we don't
Prove
know
those
if there'll be a
violations.
formal hearing.
Yeah, we
I
don't.
don't think we should base our judgments off of
No, I understand.
whether there may or may not be a formal hearing.
I understand.
Well, let's just see. I make a motion that we keep our former decision. Be my motion.
Second.
Okay, the motion by Ms. Franks, seconded by Mr. Diaz. If passed, would I keep the previous decision made by this commission in force? Discussion. If you're in favor of that motion, when your name is called, you'll vote yes. If you're opposed, you'll vote no.
Commissioner Begley,
Yes. Yeah.
Commissioner Diaz,
Yes.
Commissioner Ferris,
No.
Commissioner Franks,
Yes.
Commissioner Gwynn,
No.
Commissioner Moffett,
Yes.
Commissioner Smith,
Yes.
Commissioner Torbett,
Yes.
Chairman Grease.
Yes. So the motion passes. We're on now to number 34. Was that 30?
No, that was
That was
30.
30. Oh, the 41.
41, yeah.
Thank you.
Marcia?
Commissioners. I will turn it over to my co-counsel Pamela Vaughter.
Thank you,
She's
Shalane.
handling those cases.
So you got off pretty easy.
Yeah, but you know what? I do have to compliment you because obviously you've kind of learned kind of where we make opinions and where we don't. And so by the consent agenda for us to say on so many cases that we're in sync with you, and I appreciate it there. everything was succinct and easy to read, and that's why we agreed with you on most of those cases.
Didn't you notice that some of Lena's narratives were longer than we like to read?
Well, they're always longer than we'd like to read, when you're reading 80 pages of documents,
We're
but
just going to give you all the information so you can make a,
Just nouns and verbs, Selena, and you did a pretty good job.
of the birds.
All right, Pam, let's see, we're going to case 41, which was pulled, I know, by Ms. Branks and by myself. Marcia, you want to go?
Okay, so this was social media advertising. And I don't think there's anyone that's on Facebook that doesn't see a lot of illegal social media advertising. The rule is that your company name and phone number has to be within 1 click away. And I don't know if people don't realize that, they've not had classes in it, that they know it or not, but it's rampant. So this was a letter of warning. Ms. Matters thinks that this does matter. I would want to give something more than a letter of advertising. A letter of warning. I'd like to give a $500 civil penalty for this violation. And that would be my motion.
Is there a second to that motion?
Second.
I've got a second. Where did I hear it?
Joe,
Joe, thank you, Joe. I didn't see you there for a
he's
minute.
in the sky.
Okay, so the motion on the floor is to offer a civil penalty of $500. Is this the first violation? This
Yes,
licensee?
yes.
And is there a reason this didn't go through the executive director's office, instead came directly to us?
I'm not aware of that.
Let me look. I'm actually emailing about one right now that should have probably come to me. So I just need to make sure that they're remembering to follow the process for.
Well, we're gonna handle this either way, I think. But typically, first violations that are fairly obvious usually make their way to the executive director's office. Okay.
And what do you usually do then?
I review it, and if I determine that there's a clear violation, one that I can easily see, then I offer an agreed citation based on the schedule. And if it's something that I don't think is clear cut, then I will tell them, let's send this out for response and allow it to follow the normal complaint process.
If it's clear cut, what do you do?
I offer the agreed citation,
Of what?
$500 if it's a first violation.
That's my motion.
Just for people's knowledge, if it's clear cut, first violation, $500. If the licensee has a second violation, how much is it?
$1,000.
And what happens on the third?
I
You
have
fi-
not had to get to too many thirds,
Good.
but I do know that's in the schedule. It might go up to 1,500 and then
Okay, so that's all peripheral information to the motion, which is to offer this licensee a civil penalty of $500.
Chairman,
Advertisement.
I just want to say for your consideration too, for your discussion, this was one where by the time that I received the case, I was not able to go on and verify that post or the information, although it looked like on the chain on its way to me that someone else had seen it. So that was a little bit why I got off from that.
But
Did
didn't the respondent admit that she forgot?
She did.
Okay, that's good enough for me.
Did it disturb you that the person making the complaint was anonymous?
Yes.
Me
Because
too.
at that point, without something
Right.
that I have.
Right.
Okay, other discussion? If you're in favor of the motion that's on the floor, which is to offer a civil penalty of $500, you'll vote yes when your name is called. If you're opposed, you'll vote no. The floor is open for a substitute motion, but only for a small window. Since there's no substitute motion, so let's vote, Caitlin.
Commissioner Begley,
Yes.
Commissioner Diaz,
Yes.
Commissioner Ferris,
No.
Commissioner Franks,
Yes.
Commissioner Gwen,
No.
Commissioner Moffett,
Yes.
Commissioner Smith,
Yes.
Commissioner Torbett,
Yes.
Chairman Grease.
Yes. Number 44, that motion passes. Number 44, here's what I don't like about this case, if I've got it right. I just want to pull this. It appears there's a contract that requires a deposit of earnest money. And yet apparently that earnest money was never collected or deposited. Am I stating that correct, Pam?
That is correct.
But the contract called for it to be deposited.
It did call for it to be deposited within a certain amount of time
At a title company, or was it
with the title company.
with the title company?
Yes.
Which we've had some discussions in the past about. So my question to the commission is this: if a contract, if you're either the buyer's agent or seller's agent, I don't care which, if the contract says money is to be deposited within a certain time at a certain location, is it your responsibility to follow up and make sure it did or didn't happen? That's kind of what I posed to the commission today to discuss.
I don't know if a person's going to default in a contract, which is what this is, right? Then the agent, they can't control a defaulting party. I mean, it's just like a seller defaulting. I mean,
What I would think is the agent might be able to tell the aggrieved party, say the seller, for instance, that I know the buyer said he was going to do it, but it didn't happen. Should you know that it hadn't been deposited? Is that part of a reasonable skill and care?
Yes.
Yes, you should follow up with that title company to make sure, and they can give you evidence that it has been deposited.
I mean, you can't make them deposit it, but you should be aware that it has or hasn't
Yes.
been deposited.
And the best reasonable skill and care from both of these brokers, both would have been asking that question.
And apparently neither asked it, but the complaint is only against the buyer's agent. So
Who wanted the $2,000 back? Is that for themselves?
So I want to put this on the floor to talk about. If somebody would like to make a motion to either accept council's recommendation or some other motion, the chair's wide open to that happening. But it's my personal opinion that you're on top of your game. You know whether the money's in the bank or not. You know whether it's been deposited.
And is that your motion, Mr. Chairman?
I don't make motions. Okay.
Then I'll make that motion.
What is your motion?
what is the motion?
Let's see if we can get 2 out of this, so we could do 2,000 amount of the earnest
Hey,
money.
John,
Yes, Joe.
it looks like it all, am I missing something in it? There was a 5-day period or something for deposit, and then all this happened between January the 13th and January the 16th, which is in that period. And it looks like the agent got cut out of the other deal, maybe. Buyer texted to respond later in the meeting, she made an offer on another property. Or you're just saying that the agent that was representing the buyer should have contacted the agent that represented the seller, right? Saying that it never happened, or?
Just generally speaking, my belief is whether I'm the agent for the buyer or the seller, I should know that that money has or hasn't been deposited. Because the contract, and you may be right about the dates, and I didn't pay close attention to those dates, and that may be a mitigating circumstance totally.
I think so.
That's correct.
You see, Joe's got it. So this happened in a period of 1 or 2 days.
Right.
Yeah, it's like, I think, somewhere I
Yes.
thought there was a 5-day period for deposit, and then all this happened within like 3 days.
Well, in that case, I withdraw my remarks. I still think if it had been a period of time, we'd have a different topic, but if it's those 5 days, I think probably council's recommendation is absolutely okay.
I move to accept council's recommendation to
Second.
close.
Second.
Thank you. I have a motion by Ms. Frank, seconded by Mr. Gwynn, that council's recommendation on case 44 be accepted. If you're in favor of that motion, when your name is called, vote yes. If you're opposed, vote no. Thank you, Joe, by the way, for pointing that out.
Commissioner Begley,
Yes.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Yes.
Commissioner Franks,
Yes.
Commissioner Gwynn,
Yes.
Commissioner Moffett,
Yes.
Commissioner Smith,
Yes.
Commissioner Torbett,
Yes.
Chairman Green.
Yes, that motion passes. We're on to case 45. Marcia, no, DJ, this was yours.
Thank you, Chairman. on reading this, I just sensed a possibility here that there was some miscommunication with the complainant and the respondent and what was communicated, possibly not. And if so, if we discuss it and then we'll go with the council's recommendation. It was, the complainant stated that their agent had reached out to the respondent, and the respondent stated, quote, "it had appraised." Now that does mean one thing. If I hear that, somebody tells me it has appraised, then I presume that the value has appraised. But if they said it has been appraised, then it is in the appraisal process and we do not yet have a value. That's what the respondent would claim, I believe, that it was appraised on, the appraisal was completed or conducted on February 4th. And it was notified that it came in short on March 10th. Now, that is quite some time. So I question that and say, if I had not gotten the results of an appraisal by that length of time, my buyers would have rung my phone off the hook, and lenders, and the seller would have. And so that's kind of where it's like, well, I don't know here, but
So that might be where the $1,000 for failure to diligently exercise reasonable skill and care came from. That point.
that it could be. I guess I took a little issue with them possibly thinking the respondent was saying it was all because of the sale of home. Like they're using the appraisal as a backdoor to get their buyer out of the deal because all of a sudden they couldn't buy it without the sale of their home. Because here the respondent was pretty upfront about that information. It says that they were notified the listing agent when they learned that on February 22nd. And so I guess there could be a failure for diligent care. I mean, what was that? What kind of prompted that from council to?
My thought process on this one in particular was, in reading the actual communication that went back and forth, that it was an overt statement that it had appraised and that they relied upon that. And then it was a month later and, just took everybody by surprise that, oh, it hadn't appraised, and it kind of tanked the deal at that point. That was my thought process.
Okay.
Was the sale contingent on appraisal? It was not contingent on the sale of their home, correct?
Correct. It was not.
Was it contingent on appraisal?
The financing was contingent on the appraisal, and then they weren't able to get the finance.
So it was contingent on financing?
Yes.
Not appraisal?
Correct.
So the narrative also says that the respondent was informed on 2/4/21 that the appraisal was done, but they didn't know the appraisal was short until March 10th.
Correct.
So was the appraisal done on the house that the buyer was selling or the house the buyer was buying?
The house the buyer was buying.
Okay.
So the respondent paid for that appraisal, or their bank did?
Correct.
The respondent's client.
Right.
I don't know why the complainant is filing the complaint when they got it under contract the same day that this respondent is purporting to have notified that the appraisal was short. Kind of feel like there was some there was a failure to diligently exercise reasonable skill and care. I don't know that it's in the tune to $1,000. It sounds like there could possibly be some things that are outside of the respondent's control. The appraisal does seem to be a long time in coming, but who knows? I mean, how many appraisers are out there? How many they had backlogged? And then
What did they call though? What did they call their appraiser?
it's a good question.
And the lender notify them.
I mean, again,
So
they
that the
can't,
three balls were dropped
Yeah.
on that part.
yeah, the respondent isn't, you know, we can't find the lender, but that's not the respondent's fault, but those are all my remarks on it.
The comments. So since we pulled this item from our consent agenda, we need a motion to handle it. Chair is ambivalent about what that motion might be, but would encourage someone to make it.
I move to accept council's recommendation, but to make the amount $500.
Is there a second?
I'll second it.
Okay, seconded by Mr. Diaz. So that motion is properly on the floor. Case number 45, the motion is to accept council's recommendation with reduced civil penalty of $500. Discussion on the motion. When your name is called, if you're in favor of that motion, vote yes. If you're opposed, vote no.
Commissioner Begley,
Aye.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Aye.
Commissioner Franks,
No,
Commissioner Gwynn,
Yes.
Commissioner Moffett,
Yes.
Commissioner Smith,
Yes.
Commissioner Torbett,
Yes.
Chairman Grease.
Yes. So that motion passes. We're on now to case 53, which DJ is yours.
I wanted to make the recommendation. I move that we, council issues a letter of warning to the respondent.
Second.
Motion is made by Mr. Ferris that the council issue a letter of warning, which would warn what? What topic you want to talk to him about?
This speaks to the earnest money communication and acknowledgement of receival of funds, and that ought to be a part of their system for working with buyers and sellers. It is for me.
Okay.
Would that be reasonable skill and care?
Other comments? Let me tell you what I didn't like about this case. What I didn't like about it was where it says in the next to the last paragraph, respondent called the buyer as requested and informed him he could call his mortgage company and give them the information, and that in all likelihood, he would be denied financing, and under the financing contingency should receive his earnest money back. To me, that sounds like legal advice. If I have a problem with this case, it had to do with that, nothing else. Anytime you tell people how to get out of a contract, you're acting like you're an attorney, in my opinion. With that said, the motion on the floor is to issue a letter of warning. Is that correct, DJ?
Yeah, more discussion here as I'm reading this again. The respondent states it should have fallen upon the seller's agent to confirm the earnest money deposit, and I disagree with that on its face. It's with both parties, and that's why I would suggest issue a letter of warning, but perhaps I'm open to hearing more discussion if there's a failure to exercise reasonable skill and care, and there's a fine that ought to be associated, but a letter of warning at minimum needs to go out to this respondent.
Commissioners? Comments?
you want to make that motion then? Or did you already
He's
make
got
it?
that. That's on the floor.
Okay.
Okay, the motion on the floor is for legal to issue a letter of warning. If you're in favor of that motion, when your name is called, you'll vote yes. If you're opposed, you'll vote no. Now,
Commissioner,
just to be clear, I just want to make sure we're clear because I see a question mark or two on people's face. So a letter of warning will speak to what, DJ? What would the letter of warning speak to?
It'll speak to the practice of acknowledging receiving earnest money proceeds for your client.
So that's,
And that goes, and that should be a standard of care, whether you are a buyer's representative or a seller's representative.
So
Okay.
falling under failure to exercise reasonable skill and care.
Yes.
All right, that's the motion on the floor. When your name is called, if you're in favor of that motion, please vote yes. If you're opposed, vote no.
Question,
Yes,
who seconded
Yeah.
that?
I
Okay.
think Jeff did.
Commissioner Beckley,
Yes.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Yes.
Commissioner Franks,
Yes.
Commissioner Gwynn,
Yes.
Commissioner Moffett,
Yes.
Commissioner Smith,
Yes.
Commissioner Torbett,
Yes.
Chairman Gruce.
Yes. Motion passes. We're now on to case number 55. I think the only question I had on this, Pam, maybe a day question, it might help me out. At the end of the first significant paragraph, it says the sale closed on March 5th, 2021. No, that's not what I had. I got to hear, this is a case that irritates me.
Irritation penalty, huh?
Yeah, this is it. So here's the scenario. An elderly couple will say, let's call them out-of-state people, tell an agent they want to buy a piece of acreage, maybe 15 acres, and their budget's about $100,000. The agent shows them a piece of property that's been informed about for about $150,000. When the buyers get to closing, the sellers are not who they contracted with. But they go ahead and close, and they pay $150,000, and then find out that approximately 10 days before, the sellers had purchased it for $100,000 and then sold it for $150,000 in 10 days. I mean, that's the setup, correct?
It's the setup that the complainant alleged. I had talked to the respondent in this case, and actually she followed up with me after this was presented and sent me a copy of the contract, and it was with the sellers. The contract and the offer was actually made to the sellers
The ultimate sellers.
that it was the couple that had gotten confused. So I asked them to send a copy for me to confirm that, and I did.
So I guess my question is, was the agent for the out-of-state buyers,
Yes.
was that person a buyer's agent? Do they have a buyer representation agreement?
Look that up. I believe so, but.
This one bothered me. This one bothered me.
So I'm trying to understand this. The respondent told an agent to list the property for $150,000.
No.
No.
So
Well, it says one of respondent's agents had come to the respondents about a property to ask what she could list it for. And the respondent suggested $150,000 after viewing the property. So the respondent suggested the $150,000 listing, but the respondent is the agent for the complainant.
yes.
So who is the agent that listed the property in relation to the respondent?
The agent who listed the property was an affiliate at the respondent's firm, and the affiliate had originally come to the respondent to just get input on what it could list for. And then that was the respondent's suggestion. And then the respondent was representing the buyers. And it was something that was akin to what they were looking for. So the respondent then told the buyers about the property that's associated.
And my point, I think, is if she was representing the buyers, did she have a fiduciary responsibility to say, no, this guy just paid $100,000 for it 10 days ago, but you get to pay $150,000 for it today?
Respondent says she didn't know, what they paid for it or
But
what the.
Why would she have to tell that?
Well, if you're required to offer loyalty to client, it would be important for your client to know, and maybe that's why they filed this grievance, that they paid $50,000 more than what it sold for 10 days before.
It's public document too.
It is.
I got it. I'm just telling you, when people, this is not a flip because it actually
Right.
changed hands. That's why I like talking about these things, because I don't, it doesn't feel right to me.
I hear you. I hear what you're feeling.
Hey, John,
Hey, Joe.
and the person that bought it was either an agent in that same office or a relative of an agent. Is that the way I'm reading that?
That's what I think.
Yeah, so
Yes.
there was also some, I think, how do you want to say it gently? They bought it cheaper than the actual value might have been if there was that much spread in it. You know what I'm saying? So the first seller probably was at a little bit of a disservice too, I think, because somehow that office, came upon it and somebody in there bought it and then flipped it in 30 days for $50,000 profit.
But that's not where the complaint is.
So did you find out that this for buyer's representative versus just,
I don't see a copy of the buyer's representation agreement in the file, nor a specific reference to the buyer's representation agreement. I see both parties saying that they had contacted the respondent and about assisting them, and that there were several properties that the respondent was showing.
all right, so I just wanted to express my irritation with this type of deal. And if I'm the buyers, I'll be upset if I'm paying $50,000 more than somebody paid 10 days before. But that's maybe okay. And so is there a motion either to accept council's recommendation and let's move on, or some other motion at this point?
Move to accept council's recommendation.
Thank you. Is there a
Second.
I got a second. Joan Smith seconds that. So discussion on the motion. If your name is called, if you're in favor of that motion, vote yes. If you're opposed, vote no.
Commissioner Begley,
Yes.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Yes.
Commissioner Franks,
Yes.
Commissioner Gwen,
Yes.
Commissioner Moffett,
Yes.
Commissioner Smith,
Yes.
Commissioner Torbett,
Yes.
Chairman Grease.
Yes, and that motion passes. All right, number 66, Marcia.
Okay, so this one is, this involved, the respondent was a broker, had a broker's license in retirement status. And so they're now working for a company that buys and sells investment properties. So the respondent acknowledges his license is retired, but states that there is a personal interest disclosure clause in the purchase agreement that states sellers understand buyer is a licensed real estate in Tennessee. Buyer is not acting as transaction broker or facilitator and is not an agent for either party. So I'm confused here. If his license is in retirement, why he's why he's in this position of buying and selling. And so is this a flip? Is this guy acting as a wholesaler? What's going on here?
What he's doing is, or what the company is doing that he's employed for, is actually executing purchase and sale agreements on properties, but then they are assigning that contract for an assignment fee if somebody wants to purchase the contract and become an end buyer of the agreement. So they're not selling the real estate. They are, they're selling the contract right to purchase the real estate.
Okay, so that's called wholesaling, actually, is what that is. I just, more than anything, I wanted to bring to the commission's attention that wholesaling is becoming a really big issue in all of the United States. And Oklahoma has just passed a law that does ban the practice of real estate wholesaling. And if anybody wants me to send it to, you know, this, when you do this, you totally take away the protection of the public. There's lots of people out here wholesaling without licenses, lots and lots and lots of them. So there's going to have to come a time that we decide what we want to do about this. And I know that we can't go as far as getting legislation passed, but I did share it last night with the TR president that's from this area. And so I'm hoping that TR will take this ball up and run with it. There are other states that have pending legislation also on it. I've not heard of any jurisdiction that thinks that this is a proper thing to do. You know, the problem is you have all these people that want to give seminars, free seminars, and they teach you how to do this, and then you buy their books and stuff. And so really they're selling books. But there's just a whole litany of reasons why this shouldn't be happening. And on this particular one, I don't know exactly how he gets out of it by saying that he's just assigning the contract. Was his intent to begin with to assign the contract?
In signing, in actually purchasing, executing the purchase and sale agreement? I'm not sure. I think that's what I don't know that.
So Marcia, I had a question then on wholesaling, because to me, it all depends on what the contract says for the first guy, okay? It's a guy in New York, I'm making this up, you know, he's hustling around trying to find properties in Tennessee, puts them under contract. The contract says something. So the seller can go in there and say, you can't assign this contract. That will nip that in the bud quicker than anything without my approval. So if he's going to wholesale it, he's going to have to go get the person he's trying to sell the contract. He's going to have to get the owner to agree to let him do that. And that's the way to stop that.
And I know lots of contracts have or assign. I mean, you know, we see that.
And the other question would be, you know, is the first guy going to close? Okay, what if he can't? What if he can't wholesale it or sell the contract? You know, what does it say in there? He probably just has it under contract for a certain period of time.
So other thing that, I'm sorry.
You joke.
Other thing that bothered me, it says respondent acknowledges that his license is retired, but states there's a personal interest disclosure clause that states seller understands buyer is a licensed real estate in Tennessee. So he says he's retired, but then he turns around and says he's licensed. That's contradictory.
That's a problem.
That's a problem to me. So is he licensed or is he retired?
His license is in retired status.
He
was licensed, but it's.
So he can't be out there doing that.
So he can't do both.
Well, but here's the problem I have. It's not picking on legal, but they have consistently opined that selling a contract is not selling real estate, that you don't need a license to sell a contract. There's no equitable interest. I think I'm stating it correctly. And as long as we can't regulate that, then we really have no jurisdiction, even though to me, it's selling real estate. And a lot of times the seller who entered into that contract doesn't realize that if he can't assign it, he ain't going to buy it. But no equitable interest.
And the only thing too that on this one that made it sound a little bit better is that this is a corporation, not an LLC. And a corporation is allowed to do things that an LLC is not, being unlicensed. But do we have a license for an acquisitions director? We don't. So that's what he's saying he is. I'm not a realtor. I'm an acquisition director. So you know, there may not be much that we can do about this at this point. And you know, I'm interested in hearing what else we've learned since the last meeting, because we deferred it to this meeting so that legal could further review the legal issue.
Just as a point of question, does a standard residential contract have they have assignment clauses, correct? Or not correct? Or I guess it depends.
You can put or assigns, but there's not really, Joan, is there any information? She was chairman of that committee last year.
She's hiding for something.
Where'd she go?
Well, oh,
She just happened to have her folder.
yes, I just happen to have my folder. Yes, I did. Is that okay if I look that up? Is that okay?
You have the floor, Joan. You don't have to ask counsel.
I did. I looked straight
I
at
just don't think it has language about, you can put or assigns, but I don't think there's language in.
But I'm talking about a clause that says you can't assign this a contract without me approving it. I'm selling it to you and
And
you
you see
own it.
that in commercial. that-
Absolutely, every time.
So it's there.
Correct. It's not a bad clause to
Yeah,
have.
yeah.
Well, I think this is where folks that are wholesaling, this is where the special stipulation section comes in, where
I
they,
do not see it in here.
where they write in the language that they've been told to write in to make the contract assignable and expire at a certain.
Whoop. Well, I just wanted to chime in and say, are you looking off of the TR forms?
Yes, ma'am.
Okay. Just to keep in mind that not everybody uses that form.
Right.
So we'll need to, if we want to look at it in that context, but I understand what you're doing.
All right, ladies and gentlemen, there's very little we have or can do about the situation except entertain a motion.
I'm going to move to accept council's recommendation reluctantly. To be discussed later.
These are seconds. Steve Gwynn seconds the motion reluctantly. Although he appeared to be fairly excited about seconding the motion, so I don't know if it applies or not. If you're in favor of the motion, when your name is called, please vote yes. If you're opposed, vote no.
Commissioner Begley,
Yes. Yeah.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Yes.
Commissioner Franks,
No.
Commissioner Gwen,
Yes.
Commissioner Moffett,
Yes.
Commissioner Smith,
Yes.
Commissioner Torbett,
Yes.
Chairman Greaves.
Yes, motion passes. We have one case left. It was a late edition. Commissioners, you'll find it on your desk. It's titled Addendum to May 21st Legal Consent Agenda. We have a guest presenter. Is that correct, Mr. Green?
Yes, Mr. Chairman. How are you today?
Good, Mark. How are you doing?
I'm doing well. It's good to see you all together.
Would you introduce yourself for the record and let people know who you are?
Absolutely. My name is Mark Green. I'm the Deputy General Counsel for the Division of Regulatory Board's Legal Department. And I have asked that this matter be represented in front of you today for discussion regarding the contract and the disbursement of earnest money. Let me read that complaint number into the record just to make sure that is done. Complaint number is 2020 095 251. And this was initially presented with a recommendation that there was a violation of Real Estate Rule 1260-02-.09, Section 9, and a civil penalty in the amount of $1,000 for that violation. At that time, the commission accepted the council's recommendation and that has led me here today in front of you to have a conversation and to discuss this matter further. Let me hold up. Let me get back to, there we are. Are you ready, Mr. Chairman?
I've been ready, Mark.
Okay, I didn't want to just keep talking if you wanted to interrupt me.
I'm not going to interrupt you, except unless it's to cause you to move faster.
Okay, all right, got it.
Do that, but
All right.
tell us the issue.
We've had numerous talks about this internally, and initially, the first two times I looked at it, I was in agreement that there was a violation. However, as I have studied this more and gotten more involved with it, I think there is a conversation and a discussion that needs to be had, and I am at the point where I don't think there's a violation that did occur. And in fact, I think this is more of a contractual issue that would be best resolved by court if resolved at all. But the contract regarding this matter that set this whole thing off was the complainant, who was a buyer's agent, sent a complaint against the seller's agent in order for regarding the fact that the seller's agent had not reimbursed or returned earnest money in the amount of $2,000. When I look at the contract that was signed, the contract had basically called for an inspection, which did happen, and it had three options that a buyer, if they found anything wrong with the property, could act upon. They could terminate the contract immediately, and then also submitting reasons as to why they were terminating it. They could buy it as is, or they could submit a list of problems and allow 3 days to negotiate the resolution of those problems. What appears to have occurred is that the buyer chose option number 3. And before entering into any negotiations, they basically let the 3 days expire, and they never really entered into good faith negotiations. So at the point of 3 days, the seller's agent believed them to be in breach. The contract specifically states that upon earnest money can be dispersed by the holder, by the trust company, the principal broker for the seller, upon reasonable interpretation of the contract. And of course, that complies with Section 7 of the rule that I previously read as to what the initial violation was. So I think this is more of a contractual dispute than a clear violation, because I think the terms of the contract, which allowed for a reasonable interpretation of the contract, and the steps were clearly laid out therein, I think the seller had the right to make that interpretation. And therefore, I don't think there was a violation. And so my new recommendation would be to dismiss this.
Okay, Mark, thank you. Is it your opinion then that the selling agent made a reasonable interpretation of the contract and dispersed the earnest money reasonable?
It is my legal opinion that occurred.
Okay. That's what the contract said he could do. Is that correct, or she?
Yes. Yes.
Hi, Commissioners. Questions?
Did this go to a real estate company or a title company?
I would have to look. I don't know if you mean the check, the earnest money check?
Yeah, because the title company would have a different set of standards. They're not bound by the Broker Act. That makes a difference to me too.
Well,
I'll make a motion
Let's do it. Steve,
to accept council's recommendation.
is there a second?
Second. So
I'd second by John Moffett. Sorry, just barely beat you.
yeah, due to
Do you want
fingers
to
out.
wait and get questions?
I've got an answer.
I would like
Okay.
I
to
have an
answer.
answer.
Okay,
It went to the real estate company.
Okay.
seller's agent was holding the money. Okay, the motion on the floor is to accept council's recommendation, new recommendation, and to dismiss this case. Any further discussion? Name is called. If you're in favor of that motion, please vote yes. If you oppose, vote no.
Commissioner Begley,
Yes.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Yes.
Commissioner Franks,
Yes.
Commissioner Gwen,
Yes.
Commissioner Moffett,
Yes.
Commissioner Smith,
Yes.
Commissioner Torbett,
Yes.
Chairman Grease.
Yes. Thank you, Mark. I think that concludes our legal report. Thank you, Shalina. Thank you, Pam, wherever she has gone to. There you are back there. Appreciate your professionalism in helping us get through this in a timely fashion. Mark, do you have anything else for us?
No, sir, always good to see you folks and hope to see you in person soon.
Next June, next month.
Yeah, next June.
Next June.
Next June.
Let's hope.
All right, we have one other item on the agenda that I'm aware of, and that's the Arello Conference in San Antonio. Who wants, Caitlin, you want to speak to that first, and we'll let the president of Arello chime in if she chooses.
Yes, so the mid-year Arillo Conference is in San Diego, Texas, and it is June 30th through July 3rd. And so I wanted to have this item on the agenda to discuss, to see if any members of the commission would like to attend that conference, and open it up for discussion.
Okay, and this is an in-person conference, right, Marcia?
Yes.
Is that the first one you had?
First one in 15 months.
So we have several new commissioners that are with us. Marcia, would you like to describe what a typical conference is?
So,
what the benefits are?
Arello is the Association of Real Estate Licensed Law Officials. Yes. I've called it many things and most of them were not right, so I've had to learn this. When I first came on the commission, Eve Maxwell was the person that was our executive director. And so she invited whoever wanted to go to these meetings. And so I thought, well, I'll go. It was in San Diego. I really wanted to learn how to be a better commissioner. And so that was my reason for going. And so it's divided out. We've got like 16 different committees, from timeshare to education. Ross is on 2 education committees. And those are very important committees because they certify instructors, they certify classes. So it's actually a really big deal too. So, but you learn all kinds of different ways. There's a fair housing committee. There's lots of different ways to learn about how, what's going on at Arillo and how to be a better commissioner. We also have the Commissioner College. And that is a great thing to take to learn. I learned a whole lot more about law in that class. But every time that I've gone, my favorite thing is we have commissioner roundtables, and it's where you'll have all the commissioners in the United States, Canada, and there's 14 other countries. We've actually just been in talks with South Korea, and they're coming to our meeting in San Antonio because a lot of countries don't have regulatory boards. So we're in talks right now with Mexico and Ukraine because they need help to set up regulatory boards. But anyhow, so the commissioner roundtable is we'll sit around and what's happening in other places. From what I've learned, if it's happening in California or Washington, D.C., they're always first on everything, that it's probably coming to Tennessee. Just like I was talking earlier about Oklahoma, I've been able to get information on, it's a big topic at Arillo that we're going to be discussing is wholesaling. So you can just have a more of a knowledge of what's going on and we don't want to just do something because everybody else is doing it. And we also don't want to do it because we've always done it that way either. So it's just a great learning opportunity. And so I've gone to every meeting since then. And I've always learned something that's helped me to be a commissioner. So I would love, I don't have, Arello pays my way, so I don't, the state doesn't have to pay my way or my expenses. But I would love for some of you to come. I know, I guess nobody's been on this commission other than John and I at this point. So I would really, it's going to be a great time in San Antonio too. We're having a fiesta the first night, and the last night we're having no, not a fiesta. We actually have rented the Alamo, and we're having an event in the Alamo. So it's a dinner in the Alamo. So it'll be quite interesting. So I just, if you can go, I would love for you to come. It also helps. It helps. I know Caitlin has made lots of contacts with other CEOs. As president of Arello, I receive a lot of CEO questions. One thing that's happened recently that might be interesting to you is Alabama, the Alabama Association of Realtors, in this last legislative season in Alabama, they asked that the Alabama Real Estate Commission be dissolved, and that the Alabama Association of Realtors would take care of all regulatory facets.
How'd that go?
It did not pass. But Von Poe is their CEO, and so he's called me just freaking out 2 or 3 times. And I've tried to be able to tell him how to calmly get with those people and work things out. It gives you, though, our Secretary Treasurer is from Halifax, Canada. And the things that people are doing other places, it just helps you to have some kind of reference on, a lot of times you might hear me say nobody's doing that or everybody's doing that. And it just comes from my experience in Arello to know that these things are going on or they're not. So
I have some
love for you
interest
to
in
come.
going.
So how many people do you think the state will approve?
2 commissioners typically,
Okay.
and then staff.
And so if we have 2 commissioners go to this, there's another meeting this fall, correct?
Yes, there's one in September, the annual meeting.
Okay, so if,
That's in Orlando.
so,
And I will tell you that next year's annual meeting in September is in Nashville, Tennessee. First time ever in Nashville. They're all so excited.
Do you have something to do with it?
Maybe.
perhaps. So commissioners, the request is if you've got an interest in state paying your way, I mean, it's not going to cost you anything but time and time away from your family, unless you want to take your family along. We need to know because you got to get reservations, hotel reservations.
Yes, yeah, we have to get everything approved. So we're kind of,
Under the
this is,
gun.
yeah. this
Because
is
the
time.
Arello, we need everybody registered by June 5th to get the cheap hotel rooms. Cheaper hotel rooms. It's at the Omni on the Riverwalk.
Yeah, the cheaper. So DJ, you say you're interested?
I'm interested, and I've shared it with my wife that might be a good 4th of July deal if she wants to go, and I'd be interested in going to some of the sessions, as many as are open. So
Anyone else?
I'm interested, but I don't know.
So I'm going to put you down as a yes, DJ. I don't have a second.
have you
yet.
spoken to my wife about?
No, I'm putting you down as a yes. You have her speak to me if you'd like to.
And John is up for reappointment in June. And sometimes, lots of times, those reappointments or new appointments don't happen in June. So it shouldn't necessarily rule you out of going.
So at this moment, unless somebody wants to speak up and take the second slot, I'm going to say that the person who calls Caitlin and says, I'm in, will be the second slot. And if somebody calls after that person, you'll be out until the fall meeting. We'll make you number 1 on the fall list.
Or you can pay your own way to go. I've done that. That's how much I get out of it.
I know you've done it.
There's times I pay my own way.
All right, let's, Yeah, you want a motion to approve DJ or just without objection, DJ's one?
Why don't we just maybe say
Yeah.
approve for 2 commissioners to go
Yes.
and
Well, we would like more
3
than
staff?
2 if we could get more than 2 though.
Well, Marcia, that might be more.
I
than
know
we
it's an
can
old
get.
story, but I know
So-
how much money's in the bank
Yeah,
account
it's like
too,
a
though.
quarter of a million.
Yeah.
Well, in lieu of the fact that we haven't had any in-person meetings for the last year.
Let's make sure we have 2 people who want to go
Yeah. All right.
first.
Whoever, the next person to tell Caitlin, going to San Antonio, you've got the spot. So commission, can we have a motion just for the record, for the minimum people to go to the fellow conference?
And 3 staff and then
A
and
min-
staff.
A minimum of 2 commissioners to go to the Rello conference.
I'll make a motion.
That's what the chair's interpretation of the motion on the floor is at this point. Discussion. Let's call the roll one more time, Caitlin. If you're in
Okay,
favor,
who made the motion?
Joan did.
I did.
Joan did. Okay.
That was really
And I think,
smart.
I think John seconded it,
Okay.
before I think about it.
Go. Commissioner Begley,
Yes. Yeah.
Commissioner Diaz,
Yes.
Commissioner Ferris,
Yes.
Commissioner Franks,
Yes.
Commissioner Gwen,
Yes.
Commissioner Moffett,
Yes.
Commissioner Smith,
Yes.
Commissioner Torbett,
Yes.
Chairman Grease.
Yes, that motion passes unanimously. Caitlin, anything else to have before us?
Question,
Nothing to-
question.
Steve, Lynn?
Do you think the Orlando conference will be 2 as well? Or do you,
Yes,
okay.
there's,
Well, could you
uh,
ask for more? Just because it's been done that way forever doesn't mean that we can't ask.
I can certainly ask, there is a contract, or not a contract, a memo by the commissioner, and that's with F&A that approves a set number. And so I think
F&A, we
unless
don't pay
that,
attention to F&A, we don't care about that.
they cause me a lot of heartburn, so
Remind them that the legislature has told this commission to spend our money.
I think they would probably prefer that we spend it direct, have a direct relation to consumers.
That would be great too if we would do
They
that.
would prefer to sweep our.
We would be happy for that to happen too.
All right,
Just one reminder.
Yes.
If you are here for CE, please make sure to sign out at the back before you leave.
did everybody hear what Ms. Maxwell just said? If you're going to get credit, you've got to sign out, check out with Mr. Smith. Joe Bailey,
Not you, Mr.
congratulations on your daughter's graduation.
Yes.
Thank you.
Did you have a big part in it? I mean, helping her through, helping her study and things like that?
No,
It's all about nursing.
Just
they
right
got their mom. They got their smarts from their mom, thankfully.
It's good to know you at least admit it. I just want to check with you. All right, let's go. Joan, you're a perfect hostess. Thanks for having us. Your association, your community, the government that allowed us to use this building, spectacular. Thanks very
We
much.
enjoyed it. Thank you.
You have any comments you want to make on the way out?
Glad you're here. You want to go to lunch?
No, I want to get on the highway myself.
It's got about a 7-hour
No, I
drive.
know, I only have 5. It's Stacy.
Stacy, bless her heart. She's going to Johnson City. Y'all have prayer for her.
Any comments, Stacy? Anything you'd like to say on the way out the door?
I'm just really glad to be in person. I
I-
don't know that I could tolerate one more WebEx meeting.
I totally agree. Jeff,
No, sir, I'm good.
DJ,
No, Chairman, thank you.
Steve,
Good. Thank you.
John?
Had a good time.
It's
See
good to see you,
everybody.
John.
We see everybody.
Yeah. Marcia, any comments?
I'm thankful for Jackson and all the hospitality that they've shown us. And to our staff too, because they all do a great job.
Absolutely. All right, without objection, chair's anxious to entertain a motion to adjourn.
So moved.
So moved,
Thank
so
you,
moved, so
DJ, or was that you, Jeff? I don't care that we are
It's
adjourned.
everybody.
Have a safe trip.
Wow.
And
Drop
this room,
safe.
The real room, and
we give this to you.
Been to the real.
Did y'all fill out these sheets that she
Oh, it is?
passed out?
that's a mess, Caitlin. I wasn't really paying attention to the form as it was filled today.
Sign up for.